हाँ हाँ हाँ। कहाँ ऑफिस ले रखा है? ऑफिस कहाँ ले रखा है? अच्छा अच्छा। हाँ तो ठीक, टच में रह सकते हैं, सेम फील्ड में जाने वाले हैं तो टच में रहने में कोई प्रॉब्लम नहीं है। हाँ हाँ हाँ, सही बात है।
Morning. Good morning, Mr. Sajeev Sharma, Vishnath Kamath, Vijay Kumar. Am I audible?
Yes, sir. Good morning.
Good morning, sir. So we have. I'll switch on my video now. Just waiting for. So I hope all are healthy and COVID situation under control in Delhi also. So you, I have a few doubts now. You are all faculty members of AIOVF. Faculty members or you are?
Hello. Good morning, everyone.
Yeah. Good morning. You
Good
can
morning.
start.
My name is Sunil Kumar. I'm the administrator for today's class.
Okay, fine.
Today's class topic is real estate and judicial pronouncement by Mr. P. Rajkumar Menon, sir.
Ram Kumar. Yes.
So sorry, Ram Kumar, sir. Ram Kumar, sir, is the civil engineer with 35 years of experience.
Yeah,
It's also a valuer experience of 15 years. And his biggest achievement is that he is the first person who recognized as a valuer in the land and building asset class from Kerala state. His profile is so big, actually.
Thank you. Thank you.
So now, not taking your too much time now, I think I should request Mr. Ram Kumar sir. Now, Ram Kumar sir, please take over from now.
Yeah. Good morning, all the participants and colleagues, fellow valuers. So today's topic is real estate law and pronouncement of judgment. I think people are coming. I mean, one more person has come. Can we have 5 minutes more? Take 5 minutes more to. People are still.
Sorry, your video is not visible.
Okay, sorry, I will update just.
Now you are visible, sir.
Yeah, good morning. So, so we will start with, either pronouncement or judgment or what, real estate law. It's up to you, because we have 5 hours now. While my experience while teaching real estate laws, there are so many questions which is relevant to these laws, and mostly some laws are related to your study cases for 20 marks now by as per the new syllabus. So I would like to maybe I will divert the from the one portion to the study, because otherwise you won't understand. We won't understand the right why these judgments are given in our syllabus, or why these laws are relevant laws like transfer of property or land acquisition act. These laws are given in our syllabus. So there are case studies also. You can expect MCQs, multiple option. So we'll start with uh, to be very frank with you, sharing of slides is not
I cannot hear you, sir. Your voice is not coming. Kumar sir, your voice and video is not coming. Hello? Anyone from the foundation?
पावर फेल्यूर हो गया बोल रहे सर.
Okay. हेलो। दूसरा अभी भेजा आपने लिंक? अच्छा अच्छा, ओके 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 ओके, थैंक यू।
चालू नहीं हुई अभी क्लास, चालू नहीं हुई अभी क्लास।
वो स्पीकर कहाँ गया? स्पीकर ले गई थी क्या कल तू?
Actually, there's a power failure in Ram Kumar sir system. So actually, it's going to take 10 minutes.
स्पीकर ले गई थी क्या
You can come back. Mr. Pawan Rati, please mute your mic. So after 10 minutes, Mr. Ram Kumar will take the session. Okay.
So we'll leave or we'll stay?
No, you guys leave. No, don't leave. Stay here. In 5 to 10 minutes, he's coming. Actually, this is a
Okay.
power failure. So his system can't, is not able to work.
Okay.
Hello. Hello.
Hello.
Yeah. I'm in mobile data now. Anyway, let's start the class. Afterwards, when power comes, I will share the slides. Okay.
No problem. No problem.
Before that, let me ask you a question. All of our participants are IBBA, or they are going to appear the exam, or they are all faculties. Because,
Sir, all going to take IBBI exam.
Going to take it. Okay, fine. So let's start with the real estate laws now. So why we need real estate laws? That's the first question. Why? Can anybody tell? Real estate law. What is real estate law? Why? That governs buying and using and selling land. It is the law that governs how people acquire property. There are certain so many laws which you can acquire a property. In India, actually, you cannot. You are just transferring the deed only, not acquiring the land, because in constitutional amendment, you might have known that constitutional amendment. Earlier, it was fundamental rights. Now it is constitutional right. Constitutional right. So that is legally binding. So the title transfer actually in India is legally binding. At the same time, you don't have the whole. You are not a fundamental right like freedom to speech or freedom to gather, all those things. So before it was that is the first almost all question papers have seen this question, whether it is constitutional or fundamental right. There are 4 options. So always remember, either they will use the word IBBA constitutional or legal. Both are right. So these are all this acquirement of property is called property law, real property law or real estate property law. Both are in the same sense we are using. Real property law, real estate law, everything is same. So that is one of the questions they generally ask. So what are the important laws governing the property laws? First and foremost one is Transfer of Property Act. Please remember, the year, etc. You have to write it down in a paper and daily you go through it. Stick it on your wall. Similar, we engineers.
So there is a disturbance in the...
Days, really at my age, articles. You would like to know
There is too
whether
much
we take
disturbance
constitution.
in the voice.
Okay. Hello. Breaking.
Yes, sir.
Yeah, I think my voice is breaking. Somebody is written there.
Yes, sir.
Yes, sir.
Yeah. Whenever it breaks, please let me know. So the before going through, real estate laws, you should know the constitutional laws also. General laws like fundamental principles, derivative principles, and all. I hope you can read. If you want, I will take it later because that depends on the timing and my Wi-Fi connection. Hello.
Sir, please turn off your video. Sir, please turn off your video.
Better, yeah. Now it's okay.
Yes, sir.
Yes,
I hope so. Yeah.
yes.
So bandwidth will be less. Okay. So constitutional principle. There are our general constitution laws are there. Before going to through the real estate law, one must go through general laws also. So that you have in your study material. If we have the time, I will give you some MCQs which generally asked by the IBB exams. So it's very easy actually. See, when you need not go into the deep into the subject, but there are certain important aspects which I can give you in these 5 hours. One is Transfer of Act. This is very important. The Transfer of Property Act in 1882. Amendments are there afterwards, but even though it includes the Land Acquisition Act, etc., or many other laws interconnected with the Transfer of Property Act, 1982. Then we have Succession Acts. That is Indian Succession Act, 1925. That is also part of our syllabus. It is by hello. Hello.
I think Pawan Rathi's mic is on.
No, sir.
No, mic is okay.
It's okay now. He has muted it.
No, I didn't mute. Mic is on.
No, sir.
Not you, sir. Somebody else mic.
Yes, no, yes, yes. It's
Okay.
okay with you, sir. No problem.
Yeah, I'm comfortable. I'm comfortable always. Okay, fine. So Indian Succession Act is bifurcated into, as you know it, Hindu Succession Act, that is in 1956. Forget about the date. Then Hindu Succession Amendment Act bill was there, 2015, latest. Then comes Muslim Personal Law, all those things. That comes under Indian Succession Act. Indian. We are all Indians. So even though there are some difference in Succession Act in various religion, Hindu, Muslim religion, our constitution is enacted purposefully. So that is there. Then we have to go through the model building bylaws, which is all of us are familiar. Model building bylaws, that is national building bylaws. It is different in Mumbai, then Delhi, Calcutta, West Bengal. Is very small variations. It is there. So I think my power has come. I'll log in whenever power comes in so that I can share the PPT. Then comes Real Estate Regulation Authorities Act, RARA, 2016. This is the most important one and recently enacted, and most of you are aware of it, RARA Act and RARA Compliance Building Codes, right? Am I right?
Yes, sir.
Yeah. So RARA Act also you have to learn thoroughly, being an engineer. And also for IBB exams also, nowadays RARA comes in so many questions, 2-3 questions, two I think minimum 2 questions will be there from RARA. Then comes land acquisition, LAR, Land Acquisition, Rehabilitation and Resettlement Act, 2013. That is recently we amended to before it was only Land Acquisition Act. Now it is Rehabilitation and Resettlement, 2013. That is certain scheduled area cannot be acquired by anybody. That is actually, this is awarded by President of India, the particular area for tribes or whatever, mining areas or similar areas. That cannot be comes under Land Acquisition, Rehabilitation, Settlement Act, because Wait, I'll really unfortunate. Sunday, you are all waiting, and I mean for a class. I am spoiling. Sorry for it. It is our electricity supply issue. Anyway, let's go by a slide sharing. Okay. Some technical errors now. Let me go try it. Okay, fine. Later. Okay, now can you see my
Yes, yes,
Yes.
Indian legal system? Yeah, that's what.
Yes.
Yeah, thank you. So this Indian legal system, before going through real estate laws, we should have some idea about Indian legal system and important points there are on the real estate. So we have. I will go faster. These questions may ask in IPV exam. That's why I want to take this one also now. Fundamental rights based on American Constitution. These are the questions generally they ask either fundamental rights or parliamentary system government directive principle taken from Constitution of our parliamentary system from British system, fundamental rights from American system. So these are the three important points which you have to remember. Fundamental rights from American Constitution, parliamentary system government by British system, directive principle from Constitution of Ireland. These are the why we have our constitution become the largest in the world, because we have the largest population with various kinds of culture, religion, language, so huge diversity. So the second point is vastness of our country. We are second largest country in the world after China. So this is this is the main reason for our constitution also become very large, the largest in real sense, the largest democracy in the world. So for smooth functioning of a democracy, the Constitution of India contains elaborate provisions for judiciary, services, planning service commission, etc. So these are all notes on it. When you have that one in your study material, so I don't want to go fundamental rights. See, the fundamental rights you should know: right to equality, right to freedom, right against exploitation, right to freedom of religion, culture, and
You could
rights.
put your video off because the PPT is blur, so we can't see the PPT properly. So
You want me to off the video? I don't understand, sir.
Yes, sir, because your data is getting consumed, so the PPT is blur. We can't see the PPT pretty clearly.
Okay, fine. Company technical contract. Now is it okay?
No, sir.
Still my video is on?
It is readable, but it's a blur.
But you can see something, no? I will
Yes,
read
yes,
for you.
yes, yes.
No.
Yeah. No. Okay. I will read it. What are the fundamental rights? One is right to equality. The second sentence you can see Article 40 to 18. Right of freedom, right against exploitation, right to freedom of religion, cultural and education rights. Now, the underlined portion only you have to take care of. Right to property, omitted by the Constitution, 44th Amendment Act 1978. Can you see that? Right to property.
Yes.
It is not fundamental right now. It is omitted in the Constitution 44th Amendment. In judgment, you might have seen Rupam C. Cooper versus Union of India. Afterwards, only this amendment has come. After, I think the Cooper's judgment pronouncement was in 1977 or 71. Okay. After that, this is amended to constitutional right to constitutional remedies also. So, if you are constitutional remedies means our law and order system. You need see. Suppose you have faced with a issue, especially we are considering the real estate laws. You can approach court. You can approach lawyer. I mean, for you get the legal remedy. You can approach a court or high courts or the Supreme Court, etc., etc. So that is called constitutional remedies. Now, let's go to laws of contract. Indian Contract Act. This is, I told you, this is actually this is connected to the Transfer Property Act. Indian Contract Act is a progressive business field required to adequately accommodate the new regulations. Subsequently, the provisions relating to sales of good and partnership contained in Contract Act were repealed. New enactment, Goods and Mobile Act in 1930 and Indian Partnership Act 1932 were reenacted. So Indian Contract Act, in every contract, there are so many legal terms, which is supposed to be in IBBA exam also. When you go through this, you will find lot of Latin words. That also you have to make a list. Most of what they will ask what is last enter, etc., etc., all Latin words. So that you can I mean, make in a table and just make a translation so that you will get the meaning of in English. So that is there. So the other things are there in our syllabus. This is very important. Classic. Another important aspect, which is usually you will get 1 mark question, is classification of contracts on basis of validity. There are valid contracts, void contract, voidable contract, illegal or unlawful contracts. Unenforceable contract. It cannot be enforceable. Contract is there, but it cannot be legally enforceable. So that is called. You should know. We should know what is a valid contract and difference between the slight difference in all the wordings. Valid contract. The valid contract is an agreement that is legally binding and enforceable. First of all, it is legally binding and this is a valid. It must qualify all essential elements of a contract as laid down by Section 10 of Indian Contract Act. So in Section 10 of Indian, if you take Section 10 of Indian Contract Act, there are certain elements that which you understand. So that is called that must be satisfied by in a valid contract. And then what is void contract? You know void. Void is absence of any in space. It is void like that only. Void contract means Act defines a void contract as a contractor which ceases to be enforceable by law becomes void when it ceases to be enforceable. The example given by me is actually clear this what is actually a void contract. A agrees to pay B a sum of rupees 10,000 after 5 years against a loan of 8,000. A dies of natural causes in 4 years. So A is agrees to pay B. But due to natural causes, A dies. The contract is no longer valid and becomes void. This is called void. This question will come. A agrees to pay or somebody agrees to pay somebody for a certain amount and he dies before that the contract period is achieved. So that is called a void contract. Now there is a slight difference in void and voidable contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others is a voidable contract. Again, go see the example. Suppose a person agreed to pay a sum of rupees 10 lakhs to a person B for an antique chair. Antique properties are there, antique chair. This contract would be valid. The only problem is that person B is minor, can't legally enter a contract. So minors cannot enter a contract. That is now minor definition is 18 years. So below 18 years, a minor, if you make a contract with somebody to sell his father's or grandfather's antique chair, I mean very old chair, for a certain amount he may get a huge amount maybe. So even a painting. So that is a voidable contract. I hope you can hear me now.
Yes.
Right? Yeah. Okay. So this is the difference. Okay.
Excuse
Fine.
me.
Yeah.
In the void contract, if the death is not because of natural
yes, natural cause, it is void.
If it is not because of natural causes, it is maybe the person has
no, even in an accident.
suicide.
Okay, fine. If it is in an accident, he dies. He cannot fulfill his. That is void contract.
Okay, thank you.
Okay. So voidable contract, whereas there is a minor party is involved. Second party is minor. This is the difference. Voidable contract. So there are provisions also, of course, other than that. Okay, we'll see one by one. So this contract is a valid contract from the point of view of A, and a voidable contract from the point of view of B. That means this contract is valid for A, that is he should get the antique, but in the point of view of B is mine. I was mine. He can say I was minor when I signed the contract. So finished. As and where B becomes a major, he may or may not agree in terms. Yeah, that is the thing. After when he is 18 above 18 years old, he may sell it or may not sell it. Thus, this is a voidable contract. A voidable contract is a valid contract. This is the main important thing. a voidable contract can be, not is, it can be a valid contract. In a voidable contract, at least one of the parties has to be found to be in terms with contract. Yes, because voidable contract, A is, as far as A is concerned, it is a valid contract. So this is in a way a voidable contract is a valid contract, whereas void contract, void and voidable, there are two different voidable contract and void contract. There's slight difference only. The other party is not bound and may choose to repudiate or accept the terms of the contract. He can, he, 18 years old or 19 years old, so he can accept it or reject it. So the contract becomes void. Otherwise, a voidable contract is a valid contract. This is the difference between void and avoidable. The void contract, you cannot say, yeah, it is a contract because the person himself is not there or herself is not there. So it is not a valid contract. Now, what is illegal and unlawful contract? That is, we are listening the news every day. An agreement that leads to one or all parties breaking a law, not conforming to the norms of society, is deemed to be illegal by the court. So whatever, see, I give some money to somebody and tell him break his legs. It's an illegal or unlawful. By common sense, we all know illegal or contract opposed to public policy is also illegal. There are certain public policies. So if it goes against those public policies, then it is also called illegal or unlawful contract. For example, A agrees to sell narcotics to B. Narcotics, you may be knowing narcotics or illegal substances. So A agrees to sell narcotics to B. Although this contract has all the essential element, yeah, you can write it, you sell it, and this is my product. That all the contract agreement you can make for an year or a period or whatever, but all the essential elements are there of a valid contract, but it is still illegal. So that is you can illegal contracts are deemed as void and not enforceable by law. It cannot be enforceable by law. An agreement is not enforceable by law is said to be void. An agreement not enforceable by law is said to be void. So these are the main things in the last one. Unenforceable contracts, as I said earlier. Unenforceable contracts are rendered unenforceable by law due to some technical. The contract can be enforced against any of the two parties. Examples: A agrees to sell B 100 bags of cement for 5,000 rupees. But there was a deluge or flood or whatever in the states, and the cement were unusable. Now this contract is unenforceable and cannot be enforced against either party. Is very important for our civil engineers, because if that is called a force majeure contract, there is a clause there. You cannot sell the cement bags because of natural calamity. So it cannot be enforceable. It is not either fault of A or B. So this is called unenforceable contract. I hope you got some idea about these contracts. Okay, I'll go fast now. Hello. Hello. You can hear me, no?
Yes.
Yes.
Okay. Okay. Thank you. So it's clear now. You tell me the speed. Yeah.
Yes, sir.
Because I don't know whether you are really audible from my side or any issues in my sound variations. You can speed or whatever. You can tell me, please. I need interruptions and sometimes from that feedback, because I don't know whether I am talking to only to the laptop. When I don't hear some noise from your part or voice from your part, I'll feel that I'm just talking to my laptop only. Okay, fine. Anyway, so what is contingent contract? An absolute contract is one where the promisor performs the contract without any condition. That is contingent, unconditional. Contingent contracts, on the other hand, the owner where the promisor performs his obligation only when certain conditions are met. Yes. Here, contingent contract, some obligations are there. The promisor, that is the one who signs the contract, the first party has some obligations, conditions to be met. For example, in a life insurance contract, the insurer pays a certain amount if the insured dies under certain conditions. The insurer is not called into action until the event of death of the insured happens. So life insurance policies are, whatever we are signing is contingent contract. Very best example. We are all signing contracts in insurance. No? So even vehicle contract, automobile contract, we have the same. You can say it as a contingent. If an accident or bumper to bumper happens, then only it can be enforced. So that is a contingent contract. These are rules regarding a contingent contract. Act of party, happening of an event, non-happening of an event, happening of an event within a fixed time, non-happening of an event within a fixed time, happening of an impossible event. That can also be there. Happening of an impossible event. So these are all contingent contract. Now there are certain words which we should be familiar with. Tort. Common law jurisdiction is a civil wrong. Whatever the civil wrong, it's not criminal. Tort is always comes under civil, not in CRPC, criminal laws. It is in civil courts, civil wrong. So tort law, a suit where the purpose of legal action is to obtain from a private civil remedy. Tort law may also be contrasted with contract law, which also provides a civil remedy after breach of the duty. This is simple words. A tort is a civil wrong. We need not go more deep into it. Just to name the difference between court and what is a contract and what is a tort. It is there in your study material. Just go through it. These are all because we don't have much time to go through all this thing. I hope you have got all received the study material. You can open it and you can just go through it. There is no much difference. See this principle of danum sine injuria and injuria sine danum. These are the things, Latin words, which you should know. I think one question is sure from Latin words. This is very important. Danum sine injuria and injuria sine danum. What is danum sine injuria? Latin maxim, which means damage without legal injury. Damage without legal injury. When there is an actual damage called to the plaintiff without infringement of his legal right, no action lies against the defendant. In order to make someone liable in tort, plaintiff must prove that he has sustained legal injury. Damage without injury is not acceptable in law of torts. See one of the examples. It's a beautiful example. A sets up a rival school opposite to B with a low fee structure. Schools are now competing, no, education sector. So a person A set up a rival school opposite. B is also running a school, but with a lower fees. As a result, which students from B school is flocked to A school. So thereby causing a huge financial loss to A. This act of A is not actionable in law of tort, since it did not lead to the violation of any legal right of the plaintiff, although he sustained financial loss. So It is not considered as an illegal. He started illegally. No, this is called tort. This is the difference between the contract and the tort. Contract, you can say whatever the thing. As per the contract agreement, you have to fulfill certain things. But here, in this case, tort means A is not at all liable for any financial loss of B. So that is why they use the word principle of danum sine injuria. That is injury without legal injury. I mean damage without legal injury. Damage without legal injury. Now, what is injuria sine danum? Same. The word is just reverse. It's a Latin word which means legal injury without any damage. Just reverse. Legal injury without any damage. This implies an infringement of legal rights of a person without any actual loss. How it comes, we'll see. Infringement of legal rights of a person without any actual loss. Yeah, there may not be any loss for this particular case. I will give you the example later. Principle. Let's go to principle of vicarious liability. Principle of these are all Latin words. Volunty non fit injuria. That means to one who volunteers, no harm is done. To one who volunteers, no harm is done. A person who, after knowing the risk and circumstances, willingly and voluntarily consent to take the risk, cannot ask for compensation for the injury resulting from it. See, the person, suppose A, again we will call it A. Person A, knowingly taking a risk. He knows what is the consequences of his action. He cannot ask for any compensation. That is called principle of volunteer. That is volunty, not with injuria. A person who voluntarily abandons his rights cannot sue for any damage caused to him. He abandons, suppose he abandons his rights. Yes, I have this right, but I don't want. So afterwards, he cannot say that I have got this damage as caused, and I need compensation. No, it is not acceptable. So these are the principle of negligence. There are so many other composite negligence principles of what is assault. Assault, you know it. Assault an act creates in the mind of person reasonable apprehension of physical threat or harm. These are common words. What is battery? Battery refers to harmful, offensive, and unlawful touching of a person against his will. Battery. It is called battery. So may come. I don't. I'm not sure. Questions about battery in any of the IBBA question paper. Anyway, we should know what is a battery. Essential elements: intention to use physical force or actual physical contact. So battery is there. Then false imprisonment, unlawfully restraining a person without his will by someone who does not have any legal authority to do so, amounts to false imprisonment. Willful detention is one case. Detention without consent, detention is unlawful. So this is false in principle of nuisance. Nuisance is unlawful interference with a person's enjoyment of land, some rights over or connection with it. Two types of nuisance are public nuisance. It is an interference with the right to enjoyment of land larger by causing inconvenience or annoyance. Inconvenience in any these rules are mainly more stringent in states and USA and European countries. Even you may be knowing about our pets. They cannot make noise. Even dogs cannot bark so loud in night time. All those things. So they are trained for it. For dogs and all. So public nuisance. Private. What is private nuisance? It refers to an unfair interference with a person whose enjoyment of land causing inconvenience and annoyance of the same person. The same thing. Private nuisance. Public and private. Principles of trespass to property. I think we can go fast in this. 10:30, yeah. Trespass to property and refers to an unjustified physical encroachment of land of one person by another. We know that. What is trespass? For an act of trespass to be actionable, it is necessary that the land in which the trespass has been committed must be in direct possession of the plaintiff. If I am possessing my land, I am sitting here and somebody comes without my permission through the gate, it is a trespass. That's all. I am legally entitled to get this property where I am sitting. Also, one of the most important element of trespass to land is the intention in the mind of the defendant not to commit trespass, but to commit the act that amounts to trespass. So, an act that amounts to trespass is also a principle of trespass to property. It can continuing trespass. Continuing trespass means occurs when there is a continuation of the presence after the permission has been withdrawn. See, you are given permission for 1 year. Even after 1 year, if he comes, it is a trespass. When offending object remains the property of the person entitled to the possession. Ways in which trespass to land can occur: entry upon land, trespass to airspace, yeah, for international aviation and all, you may be knowing, or even in the naval or navy also. You cannot trespass international. I mean, there are some tangible and again, yeah, not boundaries. Actually, it is kind of a understanding between countries not to trespass through airspace. And okay, you're comfortable in your home. Somebody is digging under your property. That is also a trespass. He is making a tunnel through your building. It's a trespass. Okay. So defamation, label. These are all common things which we usually come across in news and all. So absolute liability, possession, capacity to sue, capacity to sue parents. These are land. Okay, this is here it is. This is the one of the most important topics in land acquisition. First, see, in land acquisition, generally 3 questions are there. Answer is collector. One is collector. Always collector gives that. Then market value to when the market value is to be taken. Whether it is at the time of acquiring or whether it is the cost. The answer I will tell you. This question is always asking these 3 of these questions. One is who is authority. One is what is market value is. The date of market value is date of publication of notification. I will repeat. Date of publication of notification. This is the answer for land acquisition. There are 3 questions. It comes always one or another in many question papers I have seen. Then the third one I forgot. We will see. Land acquisition. The right to fair compensation of transparency in land acquisition, rehabilitation, and resettlement act in Indian Parliament that regulates land acquisition. They lays down the procedure and rules of granting compensation, rehabilitation, resettlement to affected persons. I told you the affected persons in India. Land Law Act is actually for affected persons in India, except some other. There are some exceptions like PESA Act and all those things. Panchayat Extension Scheduled Area Act. So I told you the president designates such areas. President of India. So there it is not in compliance with that. So the act as for fair compensation. That is the first thing. Fair compensation to the affected party in a transparent manner. To set up roads, buildings, or infrastructure projects, etc. The act replaced Land Acquisition Act in 1894 in British period, 1894, a nearly 120-year-old law enacted during British rule. So that is amended in 2013. As the name is also changed, they added rehabilitation and resettlement. So in Act 2013, It is amended. Aim. What is the aim? We know. And ensure the consultation with the institution of local self-government, Gram Sabhas, established under the Constitution of India, a humane, participative, informed and transparent process for land acquisition for industrialization, development, essential infrastructure, etc. So these are the goals. Provide just and fair compensation to the affected families, just as we said. Make adequate provisions for such affected person for rehabilitation and resettlement. Yeah, that is the most important, one of the most important factors in this point. Make adequate provisions for such affected persons, rehabilitation or resettlement, or you pay some solatium. It's called solatium, that you may be knowing all those things. Ensure that the cumulative outcome of the compulsory acquisition should be affected person become partners in development, leading to an improvement in the post-acquisition social economic status for matters concerned therewith into incident. Application of the Act. So, what is the scope of the Act? All land acquisition, whether it is done by central government of India or any state government of India, government of India, except the state of now it is deleted. Okay, except state of Jammu and Kashmir, it is included in Jammu and Kashmir now. The Act is applicable when government acquires land for its own use, hold and control, including land for public sector undertakings. So the government acquires land. That is the first point in land acquisition. Government acquires land with the ultimate purpose to transfer it for use of private companies for a stated public purpose. Some private companies may, like highways, they take up the work, private companies. So government job is only to acquire the land. The rest will be done by the private party. The purpose of Law 2011 includes public-private participation projects, but excludes land acquired for state or national highway project. Yes, in 2011 excludes the land acquired for state or national highway projects. Government acquires land for immediate and declared use of by private companies for the public purpose. You have to declare immediately. What is the purpose? The provision of this Act does not apply to acquisition under 16 legislation, including the special economic zones, etc. These are exceptions. Provisional Act does not Economic Zone, Atomic Energy Act, Railways Act. These because these are all government orders, special orders, special economic zone, Atomic Energy Act, Railway Act, very important government act. So the law is not applicable to this naturally. Definitions: displaced family. Any family who on account of acquisition of land has to be relocated, resettled from the affected area. This is a displaced family. Very important factor is family includes a person, their spouse, minor children, minor siblings dependent on them. Widows, divorcees, and women deserted by families shall be considered separate families. So just for information, we'll just definition. Market value. The market value of the land is determined accordance with Section 26. So when you take Law Act Section 26, there is a process in which they determine the value of the particular land. That I will come in later in detail. Agricultural land. Land used for nursery, cultivation, crops, trees, horticulture, grass, garden procedure, dairying, poultry farming, pisciculture, sericulture, seed farming, breeding, livestock, medical help, also open land for use for grazing. This is the definition of agricultural land. Cost of acquisition. This includes solatium. What is solatium? Solatium. I pronounce it as a solatium. It is a Latin word actually. any enhanced compensation ordered by Land Acquisition Authority or court on interest. Then that means cost of acquisition includes solution first, then enhanced compensation ordered by Land Acquisition Authority or court. Demurrage payable for damages caused in the process of acquisition to the land and standing crops. In some cases, I will explain the other one. In some cases, the owner of the property having a building structure or industry, if the land is acquired partly and the land is acquired building also, it may come some part of the building also. So the main purpose is to assess whether he can run the business or industry or his house, whatever purpose the building is, the structure is there, that has to be assessed. See, if the land acquisition takes a part of it, land and building, where the collector should see that the particular without this portion of the land, whether the owner is possible to generate income or is a purpose of construction, if it is a flat, if it is a villa project, whatever, or if it is industry. So if it cannot, the government has to acquire the whole area or give the solution for the all the portion which he possesses. This is the one of the principles. The outstanding law, that one. Now the other one is, it also includes the cost of acquisition of such land, building for settlement of displaced adversely affected families, and the cost of development of infrastructure amenities such as resettlement areas. Now comes, these wordings are very important: notification and acquisition, including computation of compensation award. So preliminary notification. So first of all, we need a preliminary notification. Market value starts from here actually. When you calculate market value of the particular property, it should be from the preliminary notification. So I will say actually, in my opinion, the publication of notification date, actually it is meant for preliminary notification under section 11 of 2013 Act, must be published in the following manner: official gazette, as you may be knowing, 2 daily newspapers of locality, 1 in regional language, 1 in English. In regional language in local governing bodies, uploaded on an appropriate government website. Announcement by beating of drums. I think still it is the beating of drums. You may be knowing in SARFAESI Act, SARFAESI NPA, non-performing assets, we are still doing these things, announcement of beating drums. So these are the 5 methods for preliminary notification. The date of notification shall be date for determination of market value. This is the important point. This is the question, 1 mark. The date of notification shall be the date of determination of market value. I hope you are listening. Hello? Hello?
Yes, sir.
Yes, sir, listening.
Yeah, okay, fine, thanks. So now the notification must include the following points. What is a notification for this purpose? The following point must be other. Report of social impact assessment unit must be attached to the preliminary notification. What is social impact? How many families will be displaced? How environmentally it is going to be affected? What is the population of that area? These are all social impact assessment study. Actually, this values have tremendous scope in this area. Social impact assessor, the assessment, the report, making it report with other people, environmentalists, and people who are involved in such activities, socially how it is going to be affected. That is attached to the preliminary notification. So social impact assessment is very important point. Now, without the prior approval from the collector, this is the word first the collector appears. without the prior approval from the collector. Collector is the only see, in land acquisitions, the notification, everything is determination of value, market value, everything is done by collector, under collector. So collector, this is one question always ask: commissioner, collector, Jilla, district magistrate, or whatever, tahsildar. Answer is collector in all land acquisition questions. Objection to the acquisition may be filed within 60 days from the date of publication. See, if I have an objection, I think it is changed now to 30 days. Or even now, new law is going to be enacted by August 11. It becomes 20 now, after August 11. There is a news, I don't know, I'm not sure, but for IBB exam, we should take 60 days from the date of publication. Because I will tell you one thing, whether we agree or we disagree, maybe it is whatever IBBA question asked, it is fed to the computer. The answer is only the computer and God knows. In such cases, for example, the days, 60 days. Amendments might have come afterwards, but still the answer in the IBBA central system will be 60. So better to go with your study materials. Whatever they are given in the study materials, you go with it. Maybe it is different now. It is reducing, maybe reduced to 30 days. So within 60 days is the date of publication. You can object. If I'm an owner, you can objection will be filed to the collector. Now, this is also important. Determination of market value of land. How they are going to determine the market value? The collector, again, the collector shall adopt the following criteria for assessing the value land assets attached to it. So, how is going to do it? The market value specified in the registration of sale deeds in the area. Unfortunately, we have to admit that there is a parallel economy in this country. So, market value specified in the registration of sale deeds in the area. That is, he will take first. The second one is average sale price for similar type of land in the nearest vicinity preceding 3 years of the year in which the acquisition is to be made. You see, then also the effect is same. The average sale price for similar type of land in the nearest, nobody is going to show the full amount market value in the deeds, no. So they will take, they say they will take the higher. Some clever fellows, therefore, what they will do is, they will get the news that the particular land is going to acquired by the government. So they will purchase it, so many people, 5 or 10 people together, they will purchase it very high price, the land. So what happens when the preliminary notification comes? It is already registered 2-3 years before, or 5 years even. They know it, how it works. So when they take the average of sale price of similar type of land in the nearest vicinity preceding to 3 years, this will come. So they will get very high price. The business actually in India actually. Okay, so I hope you understand how it affects the market value of land, how the collector makes the decision, how much the market value, all those things. Okay. Where the market value cannot be determined, the state government shall specify the floor price or minimum price per unit area of said land. Sometimes the market value means registration. They are all, whenever they use the word market value, state government shall specify the floor price or minimum rate. Usually in India, we all know that we are facing it all as a valuer. If you are practicing valuer, you may be knowing it very well that registration department value never matches with, that is called guideline value, never matches with the market value. Then we now, as per now the bank standard, if you are doing bank valuations, any valuation, you have to go with the international valuation standards, IVSC. You will get another course. You have to take up that course also along with the IBBA. It's a must now. International Valuation Standard Codes, IVSC. So it's a subject. It is. There is no hearsay or whatever people say prudent inquiry. No, they won't allow that. Market comparable should be there if you are doing with market approach. So comparables now GLR is sometimes very high, sometimes very low, but reasonable price we have to achieve. I think I can give you some inputs afterwards, not now, because there is method to how to arrive market value of a particular area, particular land with help of some portals. You may be knowing, some of you may be knowing it. Some web portals are there, 99acres.com or magicbricks.com or helloaddress.com. So when you type the name and vicinity, location, everything, there may be 2 or 3 sales instances. So you can put all those things, dates, time factor, negotiation factor, size, shape, everything. You percentage, put some percentages, and you adopt that market value as per the portals. It is. I don't think it is actually IVSC standard, because in IVSC there clearly states that market sale comparison should be there in vicinity. But of course, this is out of now our scope of my subject. We go through this, but I'm remembering as a practicing valuer, I can tell you that there are methods to convince authorities, at least in future, how to be the, but it is not that scientific, I will tell you very frankly. Where the market value cannot be determined, the state government shall specify the floor price or minimum price per unit area of the said land. Now comes building rules. I think most of you knows it, so I don't want to spend time on it. Building rules. Generally, national building codes, the master plan and zoning rules, approval of building plans, existing building use, parking space, offset, no objection certificate, means of access, permission for alteration, frontage of building. I hope you know everything, this part, right? Existing building, you can, your state. Hello, yeah. Hello. I think somebody asked a question. Okay, fine. So approval of building plans, existing, these things as an engineer, we all know. I'm not going into details. If you want, I can go into details, but it's unnecessary. As an engineer, we should know it. Land and building. I think there are some. There may have some planned and necessary.
No, sir.
Aspirants. All are L&B. Okay, fine. So now we go to transferable development rights. So what is TDR? This is called TDR, transferable development rights. Actually, this is only in Mumbai. It is now applicable. That is, you can transfer the development rights to a person when land acquires or he uses. We'll see. Regulations and conditions. The owner or lessee of a plot of land which is reserved for public purpose shall be eligible for the award of transferable development rights in the form of floor space index. Very important. This is a certificate. Actually, this is a certificate. It is called development rights certificate, BRC. It's a kind of certificate you are getting based on suppose the owner of a plot government has decided to take over that public for a public purpose. It is actually, excuse me, can you hear?
Yes, sir.
Yeah, okay, fine. So okay, the owner who possesses the land and government needs for a public purpose especially in metro cities. This is not for everywhere in India. The TDR is applicable in actually in Bombay now. Now only state which follows TDR is Mumbai, because the space constraints and other things. So it's a certificate actually. That is, he can construct a building somewhere in a specified floor space index given by the government. Enhanced. If it is 1.5, suppose FSI is 1.5 in DRC, that means development rights certificate, they will show it as 2 or 2.5, because you are losing that much, from that acquiring that particular property by the government. So it is granted the particular person awarded. It is called an award actually. Development rights will be granted to an owner for reserved lands which are retainable under Urban Land Regulation Act. Urban Land Regulation Act. This is as per Urban Land Regulation Act. So you can one question you can expect is development rights certificates are issued under which act? Urban Sealing Act, Urban Land Regulation Act, Zoning Act, whatever. So you can write Urban Land Regulation Act. Urban Land Regulation Act. It is the commissioner here. Collector, forget about collector. When TDR comes in Mumbai, 3 words: TDR, Mumbai, commissioner. Commissioner will issue the development rights certificate. This is also a question can be expected. Who will issue the DCR? Sometimes development rights they will fully write. Otherwise, you will see the word DRC, development right certificate. The commissioner will issue. Okay.
Excuse me, sir.
Yeah. Okay. The built-up area for the purpose. That's why.
Excuse
Okay.
me.
Yeah.
The rights will be issued for the same land or for another
No,
land?
another place. Okay. Equally good place.
Well, supposedly he doesn't have another land then?
No, government will provide the
Government
land.
will provide.
Yes, with the DRC.
Okay.
Right?
Thank you.
Yeah. The built-up area for the purpose of FSI in the form of DPC shall be equal to the gross area of the reserved plot. There it comes. The built-up area of the purpose of FSI in the form of DPC, development right, not DPC, it is DRC, shall be equal to gross area of the reserved plot. There are reserved plot for every government. Not all the places are they won't allow to construct. There are reserved plots even in Bombay. When an owner or lessee develops the amenity on the surrendered plot at their cost, they may grant a DR in the form of FSI equivalent to the area of the development by them. Suppose in slum areas, suppose in Mumbai also, the surrendered plot at their cost, they may grant if the owner develops the amenity. If the owner, okay, I'm ready to give the road access, I will provide for them. Then also they will get the extra FSI. There are many ways to get this. FSI is very important in metro cities. As FSI is more, you can construct more floors. Instead of 7 floors, you can construct 12 floors. So that is the meaning FSI. When FSI increases, you can have multi-storied building in with more floors. So this is the basic concept of DR, development rights, and DRC. If transfer of DRC ID to take place, the holder will submit the DRC, the commissioner, with application for endorsement of the name of the new holder. When you DRC, this is another point. Development rights certificate can be transferable. You can sell it to see, if I get one, I can sell to a builder. He will readily accept it with high price. It's a certificate only. You can transfer it so that you can encash it. That means it's a money, kind of money, this DRC certificate. If transfer of DRC ID to take place, the holder will submit DRC to the commissioner with the application for endorsement in the name of new holder. So they will give the new, I will give my DRC rights to another person. But the commission has to endorse it. That's all. Generally, they will endorse it. When a holder of DRC desire to use the credited FSI certified on a particular plot, they shall attach their application for development permission. Yeah, FSI certified particular plot, they can. DRC shall not be used in the island city. So, but now I think it is changed. Anyway, if the question comes in Mumbai, island city, it is not allowed DRC. But recently there is some amendments are there. Just go through it. But as per our syllabus, it is not allowed in island city in Mumbai. DRCs may be used on one or more plots of land, whether vacant or already developed, but not to exceed in any plot of a total built-up FSI other than prescribed. That is the thing. FSI should be the same floor space index. Development rights will be granted, and development rights certificate is issued only after the reserved land is surrendered to the corporation. Naturally, when you surrender a corporation means Mumbai Corporation. Your land, the DRC will be issued. When an owner seeks utilization of DRs, that is development rights, they shall submit the DRC to the commission to endorse in writing the quantum of DRC to be utilized. So development rights, if we want to, an owner seeks to utilization, he should inform, endorse writing the quantum of DRC to be utilized. Maybe he can use partly. A DRC shall be issued the commission as a certificate printed on bond paper in appropriate form prescribed. The surrendered land for which a DRC is to be issued shall vest in the corporation of state government. Surrendered land for which a DRC is issued shall vest the corporation of state government, Maharashtra. Now we go to rent control rules. I will fast up, then we'll go for MCQs also, because MCQs are more interesting, you know, to answer question. You are all going to appear the IBB exam, you know, so better to the theory part. Of course, we should know. You should, that you can read and from your study material and everything. Whereas we know actually need to know how the IBB exam the question appears. This is the most important point. If you are IBBA aspirant, if you are already past IBBA, just go through it and make yourself more knowledgeable on this subject. Now, the Rent Control Act generally only applies on lease agreements at least 12 months. You may be knowing 12 months. Why? Rent control. We know Pagidi and license fee, all those things. So Rent Control Act generally only applies. So after 11 months, it becomes Rent Control Act. It will come under Rent Control Act. Then it will be regularized by the government, laws governing it. So there are so many complications. So landlord, for common people, I'm telling complication. Otherwise, the Rent Control Act is good for all the. I mean, as far as tenants are concerned, it is very much helpful thing. This Rent Control Act. Landlord, any person who is receiving entitled to receive rent for any premises, you know it. Premises, whole of part of any building, or whole or part of any building. Because spelling mistake is there. Whole premises, whole or part of any building. Tenant, a person who has to pay rent or on whose behalf rent is payable. Premises exempted. Some in Rent Control Act, some premises are exempted from it. Premises owned by the central or state government. Any tenancy created by central or state government. Okay. Any tenancy where the lease with due consent of tenant has been registered after the commencement of Registration Act 1908. That is also included, excluded in rental. Premises is rented to a foreign mission international agency. Yes, we cannot. Rent Control Act. It won't fall under Rent Control Act. Why? It is foreign mission and international. It is part of our diplomacy to other countries and all. So it one comes under Rent Control Act. Protection of unlawful eviction of tenants. This is the most important aspect or aim of the Rent Control Act. Protection of unlawful eviction of tenants. So the grounds on which landlord can file a suit for eviction. These are the grounds for which a landlord can file a suit of eviction. Tenants, if you want to evict the tenant, if the tenant has used the property for a purpose other than purpose rented. Suppose you provided a office building or office room or a shop for a tenant. He uses it for explosives, making explosives or something else. You can evict him by giving a file a suit. You can file a suit if the tenant is used the property for purpose other than it rented. Not paid the rent for a period of 3 months or for 12 months. Thrice in a 3 year. That is a condition. In 12 months, 3 months if he is not paid, then also you can file a suit, or thrice in a 3 year. In consecutive 3 years, if he fails to pay one month, then also you can file. Premises is required by the landlord for building, altering substantial process. Okay, if the landlord wants to alter a substantial portion of the building, that means more than 50% he has to alter or extend or add, then also he can file a suit to tenant to evict the place. Tenant has given notice to quit, but not given vacant possession of the premises. You can ask to quit, but not given vacant possession of the premise. You cannot give vacant possession of the premises. You can say to tenant that you can use the vacant portion or something like that. Tenant has violated provision of section 108 of Transfer of Property Act. If he violates 108 of Transfer of Property, that's the section, the Transfer of Property Act violation is there. You can evict him. Use of premise for immoral and illegal purpose. Immoral and illegal purpose. Tenant has failed to prevent deterioration of the premises. Yes. If the tenant is not maintaining his property, owner's property properly, and it is deteriorating, if he can prove it, he can evict him easily. Tenant has failed to prevent deterioration. That means poor maintenance. Due to poor maintenance, or he add up something and structurally makes so many cracks and all, then also you can evict it. Tenant is causing nuisance or annoyance to the neighbors, including the landlord. Yeah, then in that case also you can suit a file. Tenant has acquired or constructed, has been allotted a house or a flat. Okay, suppose you give a land for tenancy, for parking or something else. If you construct something there, then also you can, in your agreement it is not there, no? So constructing a structure or constructing anything, house or flat, it is not allowable, and you can evict the tenant. Right of way. This is okay. Now comes right of way under the Indian Easement Act. This is called Easement Act. Actually, this is I should write the Indian Easement Act 1882. Then comes right of way. In both ways, it is right. Okay, right of way. What is right of way? Characteristics of a license. That is a license actually. Right of way is a license. No transfer of interest. What is interest? A property is, there is a definition for property. That is a one question IBBA usually asks. Bundle of rights. A property is a bundle of rights. By heart, it is a question, 1 mark. Property is a bundle of rights. So no transfer of interest. So in that bundle of rights, that is interest. That no transfer is permissible in license. No interest in accretions. Accretions. Sorry, accretions. What is accretions? The process of growth or enlargement. You cannot alter the premises. That is the accretions. No, the process of growth or enlargement. It is not allowed. Neither transferable nor heritable. We all know this. A license is not transferable. Heritable. Heritable means you cannot give to your son after, okay, you used 30 years for rent, then you inform the landlord, okay, my son will take care. No, if that is honors, if honors decides, okay, otherwise it is not heritable. Personal between guarantor and guarantee. It is a personal. Personally, it is purely between guarantor and guarantee. Easement Act does not require any consideration or that the right under license must be erased by the way of contract. There is no consideration, any consideration under license must arise by the way of contract. If the way of contract, it is, if it is a contract, there is no consideration, any other consideration. The person grants the license must be the owner of the property. Of course, these are all basic things, no? Person who grants the license must be the owner of the property. Now, it creates no duties and obligation upon the person making the grant. No duties and no obligation upon the person making the grant. Owner, that is owner. You don't have any duty or obligation to the licensee. Usually revocable, except in 2 cases mentioned in the section 60 part of Easement Act. That I will come there. 60. Subsequent transfer of property terminates a license. Subsequent transfer of property terminate a license. You cannot transfer the property, that's all. A licensee cannot sue trespassers and strangers in his own name. Okay. When you are giving a license to your shop or a building, when trespassers comes or a stranger comes, he cannot sue. He cannot go to the court. You are the person only entitled to go to the court. Licensee cannot go. If it is a trespass or whatever, he can report to you, the owner. Suppose you are the owner. A license is terminated by death of either party. Yes. Any of the parties die, the license is terminated, considered as terminated. Now, section 60 in the Easement Act, I told you, what is that? Usually revocable, except in 2 cases. Section 60 of Easement, second bullet, you can see. Second bullet. Section 60 of Easement Act. What is Section 60 of Easement Act? License when revocable. A license may be revoked by the grantor unless it is occupied by with a transfer of property and such transfer is in force. That means you transfer your bundle of rights. That means through the deed. License may be, it is not applicable. We know that. The licensee acting upon the license has executed a work of permanent character, incurred expenses in the execution. He cannot do that. See, exemption. It is given the exemption. The licensee acting upon the license. Yes. If the license agreement, if you are the clause is there, you can enhance the work or enhance the job, building for attracting more people or whatever. So he can do those things. A permanent character, even in permanent character, he can do. He can make a arcade or whatever, or architectural feature, ACP, or those kind of things incurred in expenses in execution. These are the 60 Indian Easement Act exception, section 60. Okay, is it clear? I hope it is clear. Yeah. Now, Real Estate Regulation and Development Act. This is RERA. No. Okay. Real Estate Regulation and Development Act. Very important. I hope you are all familiar with this word, RERA, right? In Delhi. Actually, Kerala is the last state to sign this. Okay. So you may be knowing better than me. Am I right? RERA rules. Please, somebody can answer me. Hello. Hello. Thank you.
Hello.
You are all familiar with RERA, no?
Yes, yes.
Okay, so I can go fast because Delhi has signed before. All the only except 7 states, RERA signed in I think 2017 itself, 2018-17, that period. In Kerala now 2019 they signed. They formed a governing body now only. But even though I have taken classes in Goa, so this is a very important law which make consumer, both consumer and builder comfortable. Or it is the main purpose is to help both the parties, defaulters, whoever be the either consumer or builder, customer or builder, whatever. So establish in incorporate real estate at every state in India. Establishment of fast track dispute. This is fast track. Before that, we used to approach consumer courts. Am I right? So fast track dispute resolution mechanism. Registration of all real estate project is made mandatory with RERA, having territorial jurisdiction of such project. So once you exemptions are there, some budget homes less than some square feet and all. All other main registrations of real estate project is mandatory with RERA. It is mandatory for a promoter to upload details of proposed project in website of RERA. This is mandatory now. The promoter should update the details of proposed project. RERA shall approve or reject. This 30 days that you can. It may be a question. 30 days. RERA shall approve. How many days to approve? 30 days. Or reject. Any promoter shall not accept a sum more than 10% of cost of apartment plot or a building. That is the another aspect. Any promoter shall not accept a sum more than 10% of the total cost. Initially, I'm talking about a initial project. It has been made obligatory for the promoters to deposit 70% of money collected from buyers. It is also known fact. It's called escrow account. Escrow account. It's a separate account. It is handled by not by promoter. It is handled by RERA authority. 70% of money, so that he cannot embezzle, as you see, collect the money from the consumer, then buy another plot. No, it's not possible now. It is now obligatory for all the promoters to obtain insurance in respect of title of land and buildings, construction of every project. It should be insured. So it's clear. Okay. The promoter shall not transfer or assign his majority rights, liabilities in respect of a real estate project to a third party without obtaining prior written consent of at least 2/3 number of allottees. Even government cannot say, suppose I am building a structure, apartment. I feel after second floor, third floor, I don't have enough fund, or I don't have the capacity to complete this project. So, okay, fine. I'll ask my friend builder, okay, can you construct this? He says, okay, you carry on. No, not allowed. unless 2/3 of the allottees should agree. That means customers. 2/3 of, if there are 30 people, 30 allottees, 20 people should be agree. Should agree my proposal that I am going to transfer my rights or build the complete the project by the other person. It is okay, but 2/3 allottees should agree. This is important point, not by others. Allottees, customers, consumers, 2/3. This is important point. Both promoter and buyer are liable to pay equal rate of interest in case of any default from either side. This is what one of the I think promoter is happy about. Sometimes consumer delays the payment, so that is also default payment, and penalty clause is I think it is 15% now. Either 15% defaulter, both sides 15%. If he default 1 month default, second month he has to pay 15% of first month, the lapse month. Okay, the promoter shall compensate the buyer in case any loss caused to him due to defective title of land. This is more important. Sometimes defective titles are there. After occupancy certificate, promoter they will hand over the association, the project, apartment. Then afterwards, only after 2-3 years, we find that the title itself is defective. So in that case, promoter shall compensate. So his responsibility is throughout the life for title, as far as defective title deed is concerned. Maintenance period is 5 years. Okay, agreed. As per RARA, he has to maintenance period as given for 5 years. But title deed defect, it is lifelong. Promoter has to compensate if the title deed is defective. An aggrieved person may file a complaint with RARA. During the pendency of inquiry, RARA can restrain any promoter, buyer, or agent from continuing. RARA is very powerful. That is, he can restrain. The authority can restrain any promoter, buyer, or agent from continuing. A person aggrieved by the any direction, decision order made by RARA or by an adjudicating officer may prefer an appeal before appellate tribunal. There is an appellate tribunal for RARA. All RARA. There is an appellate tribunal. You can file the case there. If RARA adjudicating officer's decision is not in tune with your aspirations. If a promoter fails to comply with the orders or directions of RARA, if a promoter fails to comply with orders or directions of RARA, he shall be liable to a penalty which may extend to 5% of estimated cost of project. See, if you fail to comply with the direction of a RARA, 5% on the spot, 5% of the total cost of the building, total cost of the project, he has to pay as penalty. That is a big penalty amount. See, this is I know some builders, we all know it. If it runs in crores, so 5% for a non-compliance means it's a huge amount for him. His profit, maximum his profit maybe 15 to 20% we take for valuation purpose. So all of a sudden 5% is gone. If a promoter fails to comply with the orders or direction of the appellate tribunal, he shall punish with imprisonment. See, again the promoter fails to comply the orders of appellate tribunal order. If he fails to comply, then he has to go to imprisonment. Even imprisonment is there. Where an offense under this act has been committed by a company, they shall be deemed to guilty of the offense and shall be liable to proceed against and punished. Clear. No civil court. You see, this is one of the important aspects. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter of which RARA. Regulatory authority has the full power. No civil court. Usually we go to consumer court even. Even the consumer court is the only way in which we get justice earlier. But there is limitations. District consumer court can grant, I think, 50 lakhs, up to 50 lakhs. State consumer court may grant up to 1 crore. More than that, you have to go to Supreme Court. There is no other way. Previously, now, as per RADA, no court shall have jurisdiction to entertain any suit or proceedings in respect of any matter related to RADA. That is final. That means RADA authorities, rules, or whatever they, their proceedings, appellate, whether it is appellate committee or adjudicating officer, whatever may be, it is binding to both the parties. No further civil court suit filing, writ files. It's a heavy raining now. We'll go fast. Now this is important. Transfer of Property Act. Hello. Yes.
Hello. Can we have tea break for 10 minutes only, sir?
Break. Tea break. Okay. I am taking. Yeah, you are all in. Take tea. No problem. We can talk.
Okay. Okay. No problem.
We can just talk. Don't stop, because then again people has to come. No, log in.
Okay. Okay. It's fine.
Yeah. Have a key. I want to see you all. So I am seeing my this one only. What do you call? Okay. Yes, I can see you now. Mr. Satyam. I thought you are also taking tea, because all the Zoom meetings we used to have tea in in between. If you break it, no, sometimes I cannot log in, you cannot log in. Sometimes people will come after 15 minutes or 20 minutes. So we continue.
No problem, sir. No problem. No
formalities between us. We are now friends. Just like fortunately, I got my IBB in 2008. These are all fluke. You are also equally knowledgeable. I know that, but maybe I can give you some guidance, because I wrote the exam and I got some recognition. That's all. Otherwise, I am also like you only. I am actually very bad in Zoom meetings, or bad in the sense I feel ashamed, because I always feel you people are better knowledgeable than me. So I don't want to, feel I am teaching, I am something. Nothing like that. Whatever I know, I am just made a PPT presentation and I am presenting to you, and probable questions. Only plus point is I can give you probable questions which is used to be appear in IBB exam. This is the only thing which difference between us. There is nothing else. So I would like to know your names. I know the names. Niels Verdar sir, Vinesh Kumar sir, Arvind Sharma sir. No video. Paswan Rati sir, Lakshmi Narayan sir. I think I know him. Sanjeev Sharma sir, Arvind sir, okay, Malpani sir. Okay. You're all from Delhi?
I'm Sanjeev Sharma. I'm from Patiala, Punjab.
Punjab, Patiala. Sanjeev Sharma sir. I think we met somewhere, because I used to travel length and breadth of this country before COVID. Classes. Even in IEI also, Institute of Engineers, also I am an active member. So you are from Punjab but settled in Delhi, or what? You are now in Punjab? Sanjeev Sharma sir.
Yes, I am from Punjab, Patiala.
Yeah,
I am from Patiala, Punjab.
Patiala. You are staying there. You are not in Delhi.
Patiala, yes.
Oh, okay.
No, I'm not in Delhi.
Okay. Then, what about Neil Subedar Saab?
I'm
You are
from
from
Mumbai, sir.
Delhi?
No, sir,
Mumbai.
I'm from Mumbai.
Mumbai. So you have more, go through that TDR because only Mumbai is this TDR certificate is applicable nowadays.
Yes,
As
yes,
of now, not in
yeah.
Chennai, not in Delhi, not in Calcutta, and etc. What about Vishwesh Kamat sir? Kamat sir, you are from?
So I'm from Goa.
You are from Goa. I've been there in Goa. Your IIE meeting.
Institute of
You are
Engineers.
presented. I think it was in 2000. I still keep my delegation cards here. Rara delegate. Okay, I'll see. I think it is related to Rara only. I came.
Okay.
That your minister was there. Then lady was there, very high post. IAS. Lakshmi Narayan, sir, you are from Udupi. Sir, can you unmute?
I'm from Hyderabad. I'm from
You are from
Hyderabad.
Hyderabad. Sir.
Hyderabad.
Okay, I also visited there many times. Sanjay Sharma sir, Pavan Rati sir, you are hosting this, I think. Pavan Rati sir, can you hear me?
No, sir, he is a participant.
You are a participant. So who is hosting? Let me check. Vijay Kumar Gupta sir. This is the host. Okay, fine. You can take coffee. You don't have anybody in home, or you have to make yourself.
Not in the mood to have coffee.
So we have total 11 participants, including me. You can ask questions here, huh? No problem. In chat, question and all. Blood PPT.
So during
Main complaint is
during the
PPT. During again.
so during the course of the session, you referred to some study material. Is it the presentation you were displaying you were referring to, or is it something else?
I didn't get you.
So during the presentation today, you referred to some study material.
Study material is provided by your RVO, AIEI. Whether you got any study material? That's what I am asking.
Usually we get the presentations once the trainer explains everything. At the end of the day, we get the presentations
Okay,
or
fine.
any other things
Apart
which have
from
been
that,
displayed.
you don't have any study material.
No
Like
written.
see,
no.
this is a study material given to me while I was writing mandatory course.
Okay.
So there are similarly 3 books are there.
Okay.
Okay, fine. I will suggest one thing. These are all superficial. See, just go through anything, whatever we are giving. You go to Google. The best way to study IBB exam is Googling. When you Google, you will get lot of you go to a particular site. Then you will from that you will get some words, some sections, some whatever laws. Again Google that one. Again Google. It is an unending process. Googling. So you can make notes on it, and you can. This is the way you can study. All the portions they never cover in this book, or anybody, even me also, even any faculty, they can give some guidance like this. My suggestion is number one is by hearting, which are very poor on it. dates, article, sections, all those things. So that kind of years, you can write down and put on your table somewhere, always visible before writing exam. I mean,
So
this
for
is
examinations,
yes, you have to remember up to the examination hall. No, otherwise the question is similar to sometimes it is like this. They will show, for example, I'm telling, 4 children in an hospital. Similar pattern was maybe Filipinos or Thailand. Cannot recognize them. Then they will ask, who is Rajesh in this? No idea, because all the questions same look same. So don't go for those questions, because most probably you will get wrong. Most of the people are failing because of negative marks. We think only if I will get 1 mark, gone, quarter, 0.25%. No, nothing like that, because most of the people are failing by 58, 58.5, 59.75. I have seen for people who have failed 59.75 in the first chance. I wrote my exam in Mumbai, because that time only few centers were there. So I came to Mumbai, SEBI, then we wrote the exam. Fortunately, I got that time. It was very helpful. Then never attempt negative marks. Never ever. If you have doubt, 2 questions, elimination, 2, like Amitabh Bachchan's program, don't go for it. If you are in doubt, leave it, because you can score easily 60 marks. From these are some important case studies are done. Case laws also. Whatever I am saying for 1 mark, it may come. You will get it. Don't worry about it. MCQ we will discuss later if we get. I promised our host I will take 1 hour extra if you are all ready, because MCQ, it is very important. Because studying this, whatever written in the book is different, and the questions which may expect, it is more useful for you for these subjects. Valuation, okay, our online. My topics are cost and income approach and insurance. We may go for insurance also, because insurance you have gone through, I know, but insurance, they will ask 1 question definitely. Underinsured property. You know how to calculate it now. Somebody might have taught you by this time. Insurance loss. Suppose a car is insured for 50,000, and actually it cost 1 lakh. Your damage is 20,000. How much you will get? Anybody guess? Your building cost 50,000. Actual cost is 1 lakh. You insured for 50,000. Your kitchen portion is damaged for 20,000.
Voice is not coming, sir.
I'm giving an example for insurance.
Yeah.
Insurance also comes under real estate law, but it is separate subject in our IBBA syllabus, insurance and loss assessment. So I will ask you a question. Your building is 1 lakh rupees cost of construction, 1 lakh.
Yeah.
You insured it for 50,000, 50.
Yeah.
After 2 years, your kitchen portion is damaged. Kitchen, 20,000 damage.
Yeah.
We assessed. How much you will get?
10,000.
Correct, exactly. This question is
Ratio.
repeating in everywhere. All the exam, this 1 mark question will be there. Under insurance. Now, there is no use of over insuring. You won't get, instead of 1 lakh, you insure for 2 lakh. You won't get 40,000. You will get 20,000 only. So, fair, whatever the fair, it is there. Now, 1 more question in insurance. If tea time is not over, I will ask. In insurance, certain portion of the building is not considered. Which portion of the part of the building? Which part of the building is not considered in insurance?
Land.
Open part.
No, sir. No, sir. Sir, foundation. Building foundation is not considered. This is a question every time. 10%. 10% is deducted from the total cost for foundation. Right? Agreed? Please remember this.
Yes, sir.
1 mark. 1 mark is very precious in IBBA. These two questions are undervaluation plus foundation. These are two things, aspects you should remember for IBBA exam.
Sir, reason, can you give some idea about the reason about this?
Because see, when a fire outbreaks comes, or forget about that one, that part, in future part, we will go to the present part. An insurer may not be the insurance person who is coming, he doesn't know the subsoil condition. Got my point? How the foundation is done, whether it is piled. If I tell, okay, it is piled foundation, no, there is nothing. Foundation is exempted because it is not the uncertainty. It is below ground.
Not visible.
Yeah.
Not
so
visible, not able to be
visible,
inspected.
not inspected. If anything happens, they will be in trouble. So generally, they want insure the foundation. Not generally, usually. So that is the reason. The moment you file the complaint insurance, the insurer comes and take up the, if it is fully damaged, the whole area, it is his duty to clean everything, salvage, all those things. It belongs to them only. You will get only the amount, insured amount.
Is a query.
Sir.
Supposedly, I have rented a portion to some person or some company.
Yeah.
And they have say added some development things in the property. Maybe
should
that
be
can be furniture.
Written in the contract.
No,
if it is not written in the contract.
See, when you give rented property or licensed property or whatever, without a written consent of the owner, he cannot do anything.
Supposedly, he's done it.
You can complain. You can complain to anybody in court, or even first you can approach corporation or municipality, wherever they have done.
At the time of vacating, can he claim the amount for that?
Not only he cannot claim, you can deduct whatever pagdi you have got, to make it in the condition which you handed over him. So there is no claim at all. He cannot claim. It is vice versa. You can claim. What have you done with my this thing?
Can you brief out force majeure?
Force majeure, natural calamity, sir. Force majeure means it's a clause that is for natural calamities. Now COVID-19, many of the AMCs, annual maintenance services, they are not doing if you are living in a flat or an apartment or wherever, generators, lift maintenance, they are not doing. They are not. They are not supposed to do also. They will say if I called before, they used to come and repair it. Now they said we don't have people. It is containment area, containment zone. We cannot go there. We cannot travel. Travel restrictions are there. What to do? This is force majeure. It's a natural calamity, like flood deluge in Kerala. It is flooding now.
Can a tenant refuse to pay the rent?
That depends on government. Now in Kerala, in my state, government has relaxed some not to get the payment fully or something. It's a sympathetic factor is there. There is no such rules actually. But business is not there. We all know, all closed. So how can you make payment? If you want to vacate, tell them to vacate. Okay, they will vacate and go. That's all. You can't insist morally or legally now in this condition.
Legally, you cannot.
Legally, it is. No, I don't think the court. I didn't. I am also giving some buildings in tenancy, license only, but they are not paying. I am not insisting because I know no work is there. It is all shut down, so we cannot say anything. It's a doubt. Better not to ask now if you are stable, or you can negotiate with him 50%. Anyway, his advance amount is with you, right? His advance amount is with you now, sir.
What's that?
He has paid some advance amount to you, right?
No advance.
You can in license agreement. You can ask for advance also, so that in such cases you can deduct in final if he vacates that time.
Okay.
I don't know now how come the post-COVID area. You don't know how to it is going to be work. Whether they will operate it or not. These are all uncertainty and unpredictable situations. So better if you keep an advance. If he again restart his work in your premises, you can charge or deduct it from his advance. That's all. Otherwise, see, this is unexpected. No, nobody knows this situation. So court will definitely give a lenient to the tenant only. You cannot insist them. You can negotiate with them. Better to negotiate in a good terms. Okay. So let's start.
Yes, sir.
Okay, Vijayamar sir. Okay, fine. Yes. So again, I have to share the slide. I don't like to share the slide because I cannot see you. No, you can see me, but I cannot see you. So we are in Transfer of Property Act. Competency to execute transfer. Who is competent? Person competent to contract, entitled to transfer. Any person not holding title to the property but having valid authority to transfer. So these are basic things. Operation of transfer. Following will be the presumed to be included in case of a transfer. Land, house, machinery fixed to the earth. Machinery fixed to the earth. Vested and contingent interest. Vested interest. While the property is transferred, but transferee's interest does not take immediate effect, nor it is clear from deed when it will take. So, while the property is transferred, but transferee's interest does not take immediate effect, but nor it is clear from the deed when it will take. That is vested one. So, vested means malified in the sense, it is not clear from the deed. So, contingent interest. What is contingent interest? The property is transferred, but it will take effect on fate on uncertain event. Again, we have learned this. See, whenever it comes, contingent. The word contingent, uncertain event or action. Interest is vested once the desired event or action take place. That is contingent interest. We have learned that in other act also. Contingent. What is that? Contingent contract. We learned void, voidable, those kind of things. So in that also we learned contingent contract. This is contingent interest. The property is transferred, but it will take effect on fate of on uncertain event. It is not certain whether it happens or not. Interest is vested once desired event action take place. The date of sale is crucial in determining liability of charges and taxes. Yes. So in transfer of property, we need to know the date of sale. That sale, from the sale date, all the liability comes to the transferring, charges of tax, etc. Generally, this question is more relevant to study cases. Sometimes you have to add these taxes and charges, etc. in the case studies. Okay. Now, so we will go to mortgage. Mortgage. What is mortgage? You know it. We are all bank values or some other values. So transfer of interest in a particular or identifiable immovable property for securing money, advanced loan or debt. That can be financial liability. So it is called a mortgage. There are many types of mortgage. It is not that important. Don't give much importance to this. Simple mortgage, mortgage by deposit of title deed, English mortgage, mortgage by conditional sale, unfurnished mortgage, anonymous mortgage. These are all different types of mortgages. You can go through. Even you can type it in Google and you will get all those things, items. What is conditional mortgage and all those things. And IB also, I don't think there is much question from this area. Charge. Where immovable property of one person is by act of parties of or operation law made security for the payment money another. When in an amount to mortgage, the later person set a charge on the property. So lease. Lease is important. It comes under section 105 of Transfer of Property Act. Lease. What is lease agreement? Because we have to value a lease agreement. General cases, that is mostly income fetching. That is income method. But lease agreement have two interest. One lesser interest, one lessee's interest. Sometimes reversionary interest, reversionary value. If the land is later given back to the owner, reversionary value. But not all cases we won't take reversionary value of land. That we will see in pronouncement of judgment. Pronouncement of judgments. There is the last four judgments like Radha Devi versus Union of India, Anisha Sharma. There are four judgments are there. Not to consider that judgment pronounced as not to consider reversionary value of the land. Why I am telling this is the lease agreement. A lease immovable property is a transfer defined right to enjoy such property for a certain time or perpetuity. What is a perpetual lease agreement? Can you anybody tell it? Give me an answer. What is perpetuity? Perpetuity in lease agreement. Hello?
Indefinite.
Infinite.
Infinite. Okay. Another. Any other answer? Any other answer? Okay. See, 99 years and more. It is lease agreement is called in perpetuity. It should be 99 years or more. Right? This is a question. And this either it will come as one mark question, or your case study part, at least part. Then perpetuity you have to consider whether it is 50 years, 80 years, 75 years lease agreement. So to find the lesser's interest, lessee's interest, you have to be thorough with this kind of perpetuity, long term, short term. this lease agreement. So it can be any type of lease agreement. A lease of immobile properties transfer divine right to enjoy such property for a certain time or in perpetuity. Sometimes certain time, 10 years, yes, long term, 50, 60, 70, like that. Terms of lease deed is important. Yes, whenever you are valuing a lease agreement, what you will ask, give me the copy of original of lease agreement or show me the lease agreement, because the terms of the lease agreement is very important to calculate the various price values. Occupational, there are so many lease agreements are there. For example, occupational lease agreement. What is that? Land and building. Building is already there. Sometimes we will give land, he will construct, lessor will construct the building. So many types of lease agreement. So the value will vary, different. I advise you to purchase or in contact Mr. R.K. Gandhi. R.K. Gandhi book for lease agreements. How he valued the lease agreement. All illustrated examples are very, very good, and it is excellently presented. R.K. Gandhi's book. Then B.K. Sabapathy sir's books are there. Ashok Nainan sir book is there. Please write it down. You can purchase this now online or contact him. If you want, I can give the contact numbers of the. I have personal rapport with these people. Ms. Shamal Datta Saab from Calcutta. He has written so many books. One of the book is very useful. Immovable properties, valuation of immovable properties. Very good book. Similarly, real estate property by R.K. Gandhi. It's a big book, 1,000 rupees. Then Sabapathy sir from Trichy. He has written so many books on different topics. Then Ashok Nainan sir is also fantastic books are there. It will help you to evaluate many valuation assignments also. It will help you not only for IBV exam. These books, these 4 or 5 others. Okay, let's come to the subject. Terms of lease deed is important and details to be considered while assessing the value of the property. Terms of lease deed is important while assessing the value of the property. You can case study. Case studies I can explain it, but I don't have that. Maybe you will engage next Sunday the case studies, because this is very important. Lease agreement case study. So lesser's interest and lessee's interest. That's what I'm saying. Lesser's interest and lessee's interest. Here the interest means value. Lesser's how much, lessee's how much. This all depends on how much years they are used. The land is utilized, or the particular lease agreement is what period you say. If it is for 20 years, 10 years is over. Now you want to value it. So the remaining 10 years is there. You have to convert it in the capital yield. Anything you have to consider. Then only you can assess the value. Sometimes I have seen in banks 75% is only considered from the market value. No, it is wrong. You cannot arbitrarily say a certain percentage to the value. Nothing like that. There is computation calculations that you have to learn in case studies. Sometimes it may come in case study lease agreement evaluation. Okay, case study means 20 marks question. No, now it is 20 marks. Before it was 15 marks. Now it is 20 marks. So that you can score actually. You need not score full mark. Out of 6 questions, you can answer at least 3 or 4 is sufficient. All may be difficult to answer. Sometimes it is confusing in 6 marks. I have seen some question papers, so a bit confusing. So you need not don't worry about all those things, because some people say if you score 20 marks in valuation case studies, then only you will pass. No, nothing. There is no such hard and fast rule. You attempt it, whatever you know. Then in case studies, then leave it other portion. You can score some other area, probability theory. See, if you go to YouTube, and just type probability theories of 4 types. I think one lady is explaining very beautifully. There are only 4 types of probability permutation combinations. It will come the blue ball, red ball, or whatever the problem comes in MEP. She is explaining very well. So you can study, you can use YouTube for probability. Just not it. Go to YouTube and type probability theory explanations. It is as good as sitting in front of your laptop for this class. Anyway, so I'm just telling you, you note down these things because probability, one question is there from probability theory. Now we'll go to.
Sir, could you name the person for the YouTube?
No, one lady is there. I don't remember her name. But any, most probably you will get that one only. I will check if you want. I can check it now. Wait a minute. Probability, yeah, this lady's name I don't remember. You can check it. See, there is aptitude made easy, probability basic tricks part 1. It's very interesting. Probability full series, 3 episodes. I think this lady 1 million have already watched. I think she is good. Then head or tail question is there. There are so many. I mean, just spend 1 hour or 2 hour, 1.5 2 hour. You will get the clear idea about probability. Just type in YouTube probability. There are so many links you will get, and go through it. At least 6 or 7 YouTube you watch. Maybe it will take 30 minutes, 45 minutes for one class. Like that, you can spend one day like that. You will be thorough in probability. That dice is there, coins are there, balls are there, cards are with cards. So these things you can learn from YouTube only. In exactly rightly speaking, there are some tricks they will teach you, so that it is easier for you. Rather than in our classes, of course, in engineering we have learned it, but this is useful now in YouTube. Okay, sir. Shall I continue?
Yes, sir.
Yeah. Liability of lease. Disclosure, intended use, premium or rent payments, keep property in good condition. Anyone encouragement to convey to lessor, consent from lessor to consent, construct permanent structure. See, these are all lessee's liability. Rights to lessees, the liabilities. These are all in you will see in the lease agreement. So lease agreement is most important part in a lease. Okay, now comes exchange, TPA, that is exchange the property, transfer property section 118. It is similar to a barter system. Yes, it is similar to barter system. Not sale, which involves exchange of money. It is in actual terms, it is not exchange. I mean, exchange of money, but barter. Transfer property in completion of an exchange can be made in similar manner the transfer of such property by sale. Family partition, settlement, compromise settlement. See, these are not. This may be a question which constitute not an exchange. Family partition, settlement, compromise settlement. These 3 things you should keep in mind in exchange. Family partition is not an exchange. Settlement is not an exchange. Compromise settlement is not an exchange. So it is same as a paying money. Instead of money, you say I have a house there, I want to purchase it. I have a shop here. He has a house there, so I will give the shop to him. Anyway, he's going away, but he gets some rent from my shop. He'll give me the his residential property. This is called an exchange. So it doesn't involve money, but at the same time, it is a barter system. Family partition is not like that. It is there is rules. Settlement, it is there is a settlement purpose only. Compromise settlement. These are not exchange. These are all for we are doing it. This compromise settlement and all. Partition, family partition, as per our succession act, whatever comes, it is family partition. It's not an exchange or gift. Yeah, gift. Transfer movable or immovable property voluntarily by donor or to donee. Hello. Sometimes you might have seen in the deed, the word used gift deed, settlement deed, or gift deed. Gift deed. What is that? If my mother gives me this much land for you, or this property you can take as long as you look after us, for your well-being, you can take. So that is called a gift. Acceptance must be during the lifetime of the donor. Please note it. Acceptance of the gift, otherwise it is will. Gift and it is different. When the gift deed is to be done, the donor should be alive. In case of donee dies before acceptance, the gift is void. Please note these points. In case of donee die, that is, if X gives to Y, if Y dies, it becomes void. X should be alive also at the same time. So it's a void gift. Understand? So a gift to an idol or religious institution is valid. It's a valid one. If you are giving an idol to a religious worship place, institution, it's a valid one, gift. Gift deed of immovable property is to be made only through the registered instrument, signed by donor or his representative, attested by two witnesses. Whereas registration is optional for movable properties. So this is the thing. Gift deed is to be done only through registered instrument. We know what is the instrument. What is that? Registration department. You go there, sign with donor to representative, finish. 1,000. They will charge 1,000 rupees stamp duty for a gift deed. Okay. Lease granted by private and statutory bodies. Impact on valuation. So this is lease granted by private and legal bodies. So how it is impact on valuation? Right to enjoy the property for a certain time or in perpetuity of a price, a share of crops, service on any other thing of value. Sometimes agricultural land, the crops are share you can enjoy in a lease, through a lease agreement. The price is called premium. The advance payment. That's what I am saying. Don't confuse license and this one. Lease is different. In license, we say pagidi in our language, whereas in lease, it is called premium, the amount which pay in advance. Governed by Transfer Property Act 102-105. Immovable property does not include standing timber. This is important question, 1 mark. Immovable property does not include standing timber, growing crops and grass. By heart these 3 items. Question will be the 4th one is maybe security guard structure, security shed. If he writes like that, the question will be like this: timber is there? Okay, it is not immovable. Growing crops, not immovable. Grass, not immovable. Security shed, immovable. So this is the thing: timber, growing crops, and grass. I hope you try to remember this one. Timber, growing crops, and grass, not included in immovable properties. Clear? Now sections, different sections. Section 3 is related to immovable property. This is the thing I am telling you. Just take a printout or whatever you need, paste it in on bedroom or study room, office room. Because these are all you have to remember. Section 3, related to immovable property of transaction. In which section? Section 5, 7, 3, 2, they will ask. Section 3 is related to immovable property. Section 5 is related to ownership transferability. Transfership of ownership. Section 5. Section 7, competency to transfer. Age, sound mind. Yeah, you should be sound mind. You should be normal person, not abnormal. Age, about 18 years. These kind of things are dealt with. Section 7. Then section 8, stability on title. Section 8, stability. The title should be stable. Stable means there is no defects. Section 25, conditional transfer. We already seen contingent transfer or conditional transfer. Section 53, fraudulent transfer. What is fraudulent? Illegal. Section 53, a performance transfer. Performance. These sometimes they may ask which section of contains this particular act. So you have to write 3, 5, 7, 8, 25, 53, whatever. Okay. Better not to, if you are not sure, don't go for these questions. Huh? If you are only sure about the section number, you attempt it. Otherwise,
Sir,
don't
can you brief something about 53A performance?
I think we have gone through it. Wait a minute. Exchange gift. Okay, let us start with section 3, related to immobile property. Okay, so one by one, if you want, I can go through. In this act, unless there is something repugnant in the subject or context, immobile property does not include standing timber, growing crops, and grass. Those things we know. That means rooted in the earth. It is rooted in the earth, embedded in the earth, attached to what is embedded for permanent beneficial enjoyment of that too. That is section 3. Now section 5 says defines transfer of property as a transaction whereby possession of ownership property, that we have seen all those things. So the performance is, I will tell you the performance. When any person contracts to transfer for consideration any movable property by writing, signed by him or on his behalf, from which in terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract, taken possession of the property, any part thereof, or the transferee being already in possession continues in possession in part of performance has done the act in furtherance of the contract, and the transferee has performed or is willing to perform his part on the contract, then notwithstanding where there is an instrument of transfer, that transfer has not been completed manner prescribed. So performance, it is 53A means whatever is written in the contract, perform.
Perform, yes.
In short form, it is a perform. That is performance. The real meaning of what is performance.
Right.
Okay, that is why I'm telling you this. The engineer, as far as engineer is concerned, maybe a dull subject, but however, we have to go through it. Law relating to
I'm also a civil engineer. That's why I'm asking.
yeah. Most of you are civil engineers, no?
I had been in Punjab PWD B&R.
Okay, sir. Now the laws, there are law relating to the inheritance, Mohammedan personal law, shares, mahar, will, gift. I don't want to go into it. You may be knowing mahar. What is mahar? When they marry a girl, they provide mahar, will, gift. These are all Mohammedan personal law. Hindu succession law, similarly, highest of there are a category hierarchy also. Class 1 schedule, class 2 schedule, agnates, cognates. So these are all Hindu Succession Act. I will, for example, I can tell you order of succession. Order of succession is this hierarchy, as I told you. First schedule, it contains certain mother side. Second schedule contains father side. That Succession Act, as per Succession Act, the next my property, if I die, goes to, if the higher class of that is mother's side or somebody, if not there, it goes to the other party. That hierarchy, that called this kind of hierarchy is there. So I think there is no much scope for a question from this, but one question used to come. Now I don't know it is there. Who is the natural parent of a girl child? Whatever be the law, let us forget about it. The question usually comes, this question: who is the natural guardian of a girl child? What will be your answer?
Mother, sir, mother.
Exactly. Okay. So with that, I think we'll just have a temporary break in the law of real estate. It is very simple. Questions are simple, but you have to go through so many articles. As far as possible, just Google whatever terms comes. So you will learn a lot, not only for examination point of view. After the IBB exam, you feel 100% confident to take up evaluation, because you are master in it. You are the final word. So please be not that, even if you learn so much, you can be, see, most of the clients which we are encountering daily basis, like bank managers, registration department, or visa this thing. Then what? There are so many purpose of valuation, no? So that kind of things. Nobody knows about what is valuation. This is that main thing which you have to remember. So you need to teach them. Sometimes they will feel bad. Why this man one fine morning a valuer comes and teach me all those things? No, nothing like that. Because people are ignorant about it. I can specially tell you, in registration department in Kerala, they accept any value. They won't ask only one page. This is the market value is 35. They won't allow to attach the calculation or anything. For buildings now we are doing. So we give a representation already to the minister. So only thing is you have to be very particular. They don't know. Even the minister assistant PA, they don't know. So you have to spend some time with manager, even bank manager, or just WhatsApp, whatever you are learned or whatever you are getting from your after IBA examination, you have to learn. But meanwhile, to be make sure, you have to purchase some books. Data and data collection, it's very important. I can share some data of PWD. PWD engineer is there, no? So there is CPWD. They are published so many data for years. So this kind of data is useful to when you compare from 72, it is the data collection is made. I have that one. I can share with you. Then one is important books. Second one is whatever journals you are available about valuation, just go through it. Third one is data, collection of data, your area. These things are very important. Now, as far as IBB exam is concerned, I'll tell you one thing. IBB exam never, see, MCQ is more or less what you say 50-50 chance, in my opinion. Because questions are twisting, like, we won't never expect such questions from which we know the answer. I mean, we have gone through it, but the particular point we may miss. So, but it is easy for you when you go for and at least 2 months you take after mandatory classes or whatever. 1 month you have to make notes on it, every subject. Don't leave any subject. All the subjects you have to learn. You will get mark. From economics, there is 20 marks, I think, 10 or 20. Microeconomics and macroeconomics, very interesting subject. Before I was not knowing anything about economics, but now it is good to learn economics, legal, these things. Then comes probability, insurance, environmental effect. One question is very important. Arsenic. The answer is arsenic. Which of the following is not? Which of the following is not considered pollutant? Whatever. I'll check. There is some permanent questions are there from environmental. You have gone through it. Whether I don't know whether you have studied or not. I don't know. Environmental. Sir, studied.
Yes,
Okay. Okay. So the insurance you have studied, loss assessment.
yes.
Then so you completed almost all the other related subjects, right?
Almost.
Almost all. So fine. For economics, it carries good weightage mark. So because our country now, the GDP, considering the other things, inflation and everything, they give very important economics. So economics thoroughly in micro as well as macro economics. Micro is local level and macro is higher level. So that kind of things, such portion, don't leave it. Demand supply curve, Keynesian theory, whatever. So it carries marks. So one more thing I want to tell you is the values are now, once you pass the exam of IBBI, there are many fields in now opening up for valuers. Earlier also we have some of earlier cases we used to value for visa purpose. So anybody wishes to go abroad and wishes to apply for a visa. Certain foreign embassies like USA, direct traveler to obtain a valuation report. You might have done it. So Central Excise Department to certify auction value of the seized assets. Some central government, they will ask for seized, what is the market value. So Central Excise Department is using us now. Industrial operations, they are using us. When the industries want to apply subsidy, they seek advice of valuers to value asset, give valuation report. Subsidies, when they need subsidies from government, they will ask for valuation from us. Then other professions also, like chartered accountants, respected, our CEO is a chartered accountant. They need us valuers to advise regard valuation of properties. In many company balance sheets and all, they prepare. More properties has to be valued by us. So they seek our assistance. So there is that is another opportunity. then even in vigilance and CBI department, they unbiased valuation they may seek for criminal cases or civil cases, investigating vigilance department. They will ask for only IBBA qualified valuers or registered valuers are more preferred now in every field. Even banks are started SBA, you know. So when CBS investigates certain cases under disappropriate wealth or whatever, so we have to give some value for that. That is our area. Then acquisition, as I told you, land acquisition, they are using our service. Then for liquidation, IBC, as per IBC rule, IBC laws, you are going to conduct the liquidation, property liquidation value of the property. This is similar to distress value in bank or forced sale value in the bank, but a little difference definition that we will see later. After that, it mainly includes in IVSC, International Value Standard course, that is compulsory for us after passing the exam. After obtaining your certificate of practice, you have to undergo this IVSC, International Valuation Standard. So where the liquidation value of a company or a fair value of the company, all those things. Even High Court approaches us for the liquidation of some properties now. Now that changed. High Court is not, it's changed to NCLT and all. As per our company law comes into effect, it becomes not in court, no, NCLT or CLAD, the NCLT, DRT, debt tribunals. They are all of them. I mean, they only company registered values like us, IBBA passed registered value can do the job. Nobody else can do that job. NCLT, Special Companies Act. When then lease, I told you, lease cases are much more than we thought before, because in government properties, most now only I came to know, so many industrial projects are in lease agreement that they started. They given lease for so many people, they are not returning. So many cases are there. So lease agreement is very important. You have to learn to learn it thoroughly. What is lesser, less is interest, whatever it comes. Then you may be knowing HP and IOC and all. They will petroleum companies in future lands, or they consider main road lease. It requires clarification from value to know the value to be certified by market value, to be certified by the what you call registered values. So there are so many insurance. Insurance is there. Then comes public limited. They want to give amalgamation, merger, acquisition, disinvestment, restructure. These are all things comes under now a new avenue for valuers, fair rent, ground rent, such etc. We are doing taxation. For taxation, very important capital tax gain, that I will give you a class if you want in future. It's very important topic which requires some skill and knowledge about it, but it is not included in the IBBA syllabus. I think capital gain is IT, usually 34 AB values, but certain rules are changed. So capital gain tax has to be valued by IBBA also. IBBA is preferred, I think, because we, as far as IBBA is concerned, sometimes the continuous education program, we learn more about this. So you need credit hours, no? After passing the IBBA exam, you have to attend certain continuous education program and earn 16 credit hours per year. So in online, you will get 1 or 2 points. But in our period, we have to travel so many places and get the points. So 16 points. I got 78 points last 2-3 years, 70 that average, because I never see as a 16, earning 16 points is not a matter. There is acquiring the knowledge on various subjects and topics is much useful for you in this field. Whatever you spend, it will come back to you. So with that, I think we can have a break now. for a half an hour. I don't know. You decide. I don't want break, but what is your lunch time? 1 o'clock maybe, right?
So after the break, do we have the MCQs that we'll be
No.
going through, or
After the break, judgments are there, no? Judgments. Then we will go for some MCQ question answer or interaction. Any doubt in any topic I told you, so that I can clear you up. And I mean, if you want, you can write to me. I will give you my email ID and telephone number, or WhatsApp me. Whatever topic comes, if I'm not that expert, but I can clarify with other faculty or any other member, so that I hope easily pass this exam. You won't I mean, participating. I mean, not only participating, you won't reading the topic many times, so that you'll be familiar with the words. The word, legal words are very difficult to get. Not for me, it's difficult. Generally difficult for grasp the real picture. So I think after lunch we can go for judgment pronouncement, case laws. It is called. See, there is a difference between two topics in one is case laws, one is case study. Case study is valuation study. That is study of a particular case. Case laws is judgment pronouncement. So we will go. The first time only I am seeing from any other faculty. No other faculties has used this, and your CEO has very beautifully named it as judgment pronouncement. So no confusion now. Judgment pronouncements. That is judgment, purely judgment. This person versus some in court cases, which is helpful for valuers to remember always, so that one or two questions may come. One question is sure. So for out of 12, there is the easiest way to score the 1 mark. One is this one. 12 case studies, out of which one is it will come for an exam point of view. So judgment pronunciation we will go after the break. Meanwhile, if you want to ask me something in other topic also, you can have, or you can type it there. If possible, I will answer it today itself, or in next classes, or if they engage me for next classes. If you are interested, I can take any class, repeat class, whenever you want. Just inform me, because this is my passion for taking classes. Especially, I don't want, I mean, to be very frank with you, this law of real estate is a dull subject, I know it. But even though we can, we should learn it. It is a must for us to learn the laws. So these are the simple laws: transfer property, law act, what are the things in other Hindu succession, and it is nothing to do with our syllabus. But transfer of property act, then contracts will be the general contract area, then then TDR, transfer development rights. Usually it comes.
we can't hear you.
Again.
We can't hear you well.
Okay, fine. So in short, the general principle. Some questions you can expect from Constitution as well as contract acts. Whereas in real estate, laws are different. It is not same as contract, law of contract. So these two, Constitution plus contract, you have to learn yourself, because it is not included in real estate. It might have taken class by some other faculty. I think so. Otherwise, it should be included actually. So law of real estate is a must, and judgment pronouncement also. That is case laws. So after 30 minutes, we can join again or what? Or we will continue. It's up to you. Or don't cut the thing. You can have the food and come back. It is all up to you, your convenience. I am quite comfort.
Okay. So back by 1:15.
1:15. So log out and come back or what?
Oh,
Log out?
Also, you can keep this on only. Keep the video
Yeah,
off.
why don't you keep this on? Just put our pictures.
okay. Okay.
So
No
why
problem.
we want to? I don't, because I am afraid. If once you log out, I don't know.
No
It is
problem.
possible with this climate to get inside. So I will just stop my video, and I will have my lunch. Come back. Lunch? Not lunch. I have break. That's all.
Come back on 1:15, na, sir?
1:15. 1:15 is okay.
Okay, right. Bye.
Yeah. Bye. So can we start? Hello? Hello?
Yes, sir.
Yeah. Participants has come.
I think some are still joining.
Yeah, okay, fine. Kindly tell those who are joined, unmute and say yes.
Yes.
Yes, okay. Mr. Arvind has not
Yes,
come.
sir.
Yes, sir.
Yeah. Akshay Malpane has not come. Arvind. Mr. Arvind Sharma, Mr. Jadan Malik, not yet come.
All are come, sir.
All are come? Okay, fine. Let's start. So now we'll start with the judicial pronouncements, judgments. So that can be done through by same procedure. We'll go for slide sharing. I don't know where to get. Okay, case laws and judgments. So let's start. The first one, Rustam C. Cooper versus Union of India. Before starting there are, as you know, there are 10 judgments only. We have to learn, out of which one or two questions may come. One is one will be certain, and the other maybe. So to learn this easy, Rustam, you take first letter, Rustam C. Cooper, R. Then relate to the any of this word. It is actually tangible properties. That is, intangible and tangible properties are there. So this is related to tangible properties, so mainly. So you can say RT, by heart it, like that. It is a kind of by heart, you know, the tricks. So what is Rustam C. Cooper says? Property means the highest right of a man can have right to anything. It includes ownership, estate, interest, incorporeal things, also rights such as trademarks, copyrights, patents, etc. So court has included all types of properties, tangible and intangible also. What is tangible? What is tangible property? Can anybody say?
Something which is measurable.
Again? Again, sir?
Something which is physically measurable.
Yeah. Then intangible is like trademarks, copyrights, patents, etc. Correct?
Yes, sir.
So this is regarding intangible and tangible properties. Rustam C. Cooper. In 1970, the Supreme Court, in its judgment of Rustam Cooper versus Union of India, popularly known as bank nationalization case. This is the one which led to bank nationalization case, 1970. Held the Constitution guarantees the right to compensation, that is equivalent money of the property compulsorily acquired. The property which is compulsorily acquired earlier was not paid. That means, so after this judgment, this whatever property right with us, it should be compensated compulsory if it is compulsory acquired. So I just put a note on it because I thought it is important to know this fact. The 25th Amendment of Constitution India, officially known as the Constitution 25th Amendment Act 1971, curtailed the right to property. See, that has come in 70 and 71. This act has come, 25th Amendment Act. Curtailed the right to property and permitted the acquisition of private property by the government public use on payment of compensation, which would be determined by Parliament and not the courts. So this is called a constitutional right. That is why property is called constitutional. It is, before it was fundamental rights. So this point you should take note. 25th Amendment. 25th Amendment by the immobile property valuer. You should always remember 25th Amendment is the amendment which made the property constitution legally binded, not a fundamental right. This is an important point. Okay, that is Rupam C. The Rustam C. Cooper versus India Union. This is the judgment pronouncement. Don't go deep into it. If you want, you can get to the Indian Kanun site. Indian Kanun. Write down. Indian Kanun. That's a website. They contain everything. You just join, login with a register it. Then you can get all the court judgments, whatever you want. Because court judgments are very important. Not only this one, sometimes to protect ourselves in valuation process. So precedents will take no. So the how a valuer is responsible for a particular event, a particular value or particular action. So there are court judgments which protect us from those kind of if malified. It is in malified. I mean, if you are intentionally done, then you are supposed to be penalized. But most of the cases, land and building, we cannot do much like, you know, exaggerate the value or something like that. It's very rare case. So in case it comes, you should be thorough with this knowledge. I mean, judgments. Not only this one, there are other judgments which is I can I can send you in email or whatever process means which support us in court. when you want to, you are in trouble, you can even lawyers may not be knowing all the this kind of judgments. So there are judgments which are values will be in safer side. That is the one. So these are all related to our real estate laws. Sorab Talati versus Joseph McCain. So Sorab Talati, yes. Take a word from that. Yes. The court approved of investment theory to fix standard rent of the rent controlled premises. Return or yield from gilt-edged security is the basis of determining the fair return to the landlord for his investment in land and building. So this is mainly for rental property, standard rent fixation. This is for Sorab Talati SR. Now RT is over, SR comes. Now it is for standard rent control property. This is the question. See, they will ask judge pronouncement fix the standard rent of rent control return of gilt-edged security. This word you should remember. This is by government gilt-edged security means a government. It is covered by government. So gilt-edged security is the basis of now we suppose we deposit a certain amount FD fixed deposit in a government scheme. It is a gilt-edged security because that will get you a minimum income. So the next page we will see. With respect to the building built after 1940, the only fair criterion that the court must adopt must be based on reasonable return to the landlord on his investment. So what should be the reasonable return? Reasonable return we can expect. It is not hard and fast rule. There is no hard and fast rule. A reasonable rate of net we can take in calculations. When you go for case studies, sometimes you have to assume the most of the data they will give in case studies. It is written, but in case it is not mentioned, you can assume reasonable rate of net return of investment allowed was 1.5%. That is more than average yield of government security. You will add a little bit more than 1.5 yield, government yield security on the cost of land. For this is for 1.5% for land investment, whereas 2.5% for building value of the building. For leasehold property, you have to add 1% on both types considered. Whether it is land 1.5 plus 1, for building 2.5 plus 1. Why? There is extra risk because you cannot like other contract, you cannot terminate a lease contract that easily. You cannot return back after. You can get back your property or land whatever, but after the lease period only. So if it is suppose a long term, you are lifelong, suppose you lease the property at the age of 30. So if it is for 70 years, so in practical, your lifelong, it is a lifelong lease agreement for such people. So there is an extra risk is there. So 1% will be added for extra risk. I hope you got the point. For land and building, land 1.5, building 2.5. If it is leased, add 1% extra for 4 types. This is clear from Sorab Talati versus Joseph McCain. Okay. Now, next come Commission of Tax versus PN Second. Forget about the government part. This Commission of Wealth Tax, you take only the name PN Second. PN Second. What he says, what the judgment pronounced in determining the values of the leasehold interest of assessee in the land of, this is assessee because maybe for capital gain in the land of purpose of wealth tax. Yes, wealth tax. One more thing, you may be knowing this thing. You are all 34 AB values, I think, under Wealth Tax Act 1957. So wealth tax means it is abolished now. 2017 budget, it is abolished. You no more pay for wealth tax. Anyhow, the act is still there. So In that case, the price would have to be reduced by 50% of unearned increase in the value of land. Okay, this is the point of second. Unearned, whenever you get a question from these 10 points, 10 judgments, pronouncements, wherever unearned increase, the word used, directly right, it is from P and second. Take the choice, whether it is second is there. So SU, unearned increase, or SUI, whatever comfortable for you. So whenever comes unearned increase, unearned means when you lease out a property, there lesser is giving you his terms as per terms, but there is unearned increase will be there for land. Suppose it is unearned increase. That means lesser is not paid for anything for that particular part. That increment is called unearned increase. This is that is happening in natural cost, unearned increase. So that portion 50% to be reduced. That means 50% actually you have to pay to lesser. That means owner. This is called unearned increase. Okay, I wrote there. This unearned this is called unearned interest. And determining the value of the leasehold interest of the assessee in the land of purpose of assessment to wealth tax. Don't go for wealth tax now, because wealth tax is not there. But for the assessment purpose, still we are using this. The price which the leasehold interest would fetch in open market. In leasehold agreement, I told you the valuation of leasehold agreement. You should use this one. Would fetch open market, would not affect by the burden of restriction contained in the lease deed. Would have to be reduced to 50% of unearned increase in the value of land on the basis of hypothetical sale on the valuation date. See, in that case, suppose hypothetical sale on valuation date. That particular valuation date, how much it will earn? So 50% of that land portion is given to the lesser interest. Okay, this is the Commissioner of Wealth Tax versus P and second. So remember that whenever second comes, just remember unearned interest increase, unearned increase. By heart it now. Don't worry, so that you won't feel because there are 10 judgments. No, very easy to remember. Now comes Wagner Co. and Co. versus District Valuation Officer. Forget the District Valuation Officer part. For time being, you can learn this in detail if you want in Indian Canon. The whole judgment is there. So this is nutshell of the judgment. Combination of methods: owner occupied, sale comparison, tenant portion, capitalization method. These are, I hope you learned almost. Otherwise, we'll see. Okay, adopted by DVO, that is divisional officer, and his approach is not acceptable. It relates to the assessment of annual value of self-occupied building, and the annual value must be determined on the basis of the standard rent determinable under provision of Delhi Rent Control Act. This is judgment is pronounced under Delhi Rent Control Act. That time there was strict, only in Delhi there was Rent Control Act strictly followed. So this is related to Delhi Rent Control Act. It is something related to Delhi Rent Control Act. Wagner means. So it relates to the annual value of the self-occupied building. Annual value must be determined on the basis of standard rent. It is called standard rent, determinable under the provision of. Wherever standard means, it is determined by the government. Standard rent, standard this, standard that, wherever it comes. So it is under the Delhi Rent Control Act, standard rent. So this like W, you can connect with the standard rent or Delhi Rent Control Act as you like. You Delhi, especially WD 14. So WD, it's okay. Delhi Rent Control Act, WD. So there is a spray of WD 14. So you can compare like that. WD. So Delhi Control Act, it comes. I hope you are clear. Okay. Hello. Hello.
Yes, sir.
Can anybody? It's clear, no?
Yes, sir.
Clear.
Clear. Okay. Thank you. Now comes Javaji Nandan versus Basic Revenue Divisional Officer. Again, you take Javaji. So what is that? Basic valuation register prepared and maintained for the purpose of collecting stamp duty cannot form foundation to determine the market value of the property under the registration. All the valuers knows it. All the valuers knows this procedure, because when you go for you are writing GLR, whether you have done any bank valuation, any valuation, we take land value, guideline value as government rate. You can go to registration department portal, you will get it. It is public domain. It is public domain. You can type fair value of Delhi. You can get whatever measurement you are using, square yards or square feet or quota. Different part of country, different grounds are there in some of area. In Kerala, it is cent. It is called cent. 100 acre, 100 cent is a 1 acre, like that. So whatever, the unit is not this thing. So market value is nothing to do with stamp duty purpose value. Basic valuation register prepared and maintained for the purpose of collecting stamp duty cannot form foundation of determining. So it is see some GLR value. That is why I am telling some GLR value is very high. So in some places in India, I know generally in my state it is very low. In metro cities it is very high. It depends. In any case, don't take it as a market value. That is what Javaji Nadan case. So J is connected to market value. Okay, JM. J is connected to market value, not stamp duty value or stamp duty cannot be determined. High Court found that basic valuation register has no evidentiary value, in that it had no statutory basis. There is no statutory basis, no legal base for stamp duty. This judgment, from this judgment only we are writing by my prudent inquiry in the locality, I found the rate this much to this much, range value, etc., etc. You can you may I mean I don't know how many of you are doing valuation as a profession. Okay, anyway, in values used to write like that meticulously. I inquired the locality and found that value ranges from 5 lakhs to 6 lakh. But whereas the in government registration department may show 50,000% or 50,000 per yard, square feet. It doesn't mean anything. So High Court found that registration no evidentiary value, evidentiary value, and it had no statutory basis. So this thing you have to remember. Yeah, this case, Javaji case, it is related to market value. Okay. So this is the fourth one. Now the fifth one, Chimanlal. Yeah, sir.
What if there is a registration done at the stamp duty amount, suppose?
Yeah.
Registration, a sale deed takes place. Supposedly the amount is 1 crore. The sale deed.
Okay.
And at the same time, a valuer is giving 1.5 market value.
No problem. If he is convinced, market value is there. If you are convinced by brokers, or you can write document writers, you can inquire with village officers. Village officers, the government department never entertain us. Registrar department, they never entertain us. You have to get it from RTI, right to information. So those things, forget about it. Nobody will wait for 1 month to get a market value. So you make inquiry, local inquiry. Then you can, I told you, you can, another method is go to web portal. Real estate web portals are there. You can note down this names. 99 acres, 99 acres, ACRES, 99acres.com. If you go there, You get state, town, district, town, etc. Then when you search it, you can get the localities near that portion, the area. So they will invite the selling purpose. They might they advertise. People will advertise. So many advertisement will be there. So they will say 3 lakh to 4 lakh or 3 crore to 5 crore. So what you have to do anyway, when you come to for a selling or a buying purpose, you will negotiate. So there is a negotiation factor. You can take it as you like 15% or 20%. Reduce it. So if it is 10 lakhs, you reduce 20%. So 0.8, 8 lakhs. The property value, that particular. Similarly, you will get 3 or 4 sale instances or proposals from these portals. Hello address, HELLO address, helloaddress.com, magicbricks.com. You go any of this site, three or four sites you can visit. You have to sit, but to prepare this thing, you have to take printout, and you can make a evaluation grid. I can show you if you want. I can send you. Evaluation grid means you will make an Excel sheet, various characteristics, comparing with subject property, comparing to these 3 sales instances. So shape of the plot, you add, okay, ours is good, rectangle. The other one is not that good, minus 10%. Then comes civic amenities, proximity to civic amenities like hospital, railway station, colleges, etc. There is some college and hospitals in my property. Okay, this property doesn't have, this property have. So this is this property minus 5, that property plus 5. Finally, you will arrive a figure which is almost same if your calculation is correct, because you are regarding the property land characteristic is okay, or building, even for building specification, that building is less, inferior specification, so I deduct that from that cost. Time factor, it is sold in 2015, so I am going to add 1% more price for land for every year. That is up to you, because land price always increases, but generally now there is a market slump, especially COVID impairment is there. So you will minus, you can even minus also time factor, because there was a peak time in all India real estate market. Peak was, I think it is in 2016 or 2015, 16, that there was very high. Then market slump started showing because of parallel economy is clamped by the government, demonetization, etc. Whatever action taken by the government, it has decreased the price. Some means not decreased in the real sense. The actually happened is there is no buyers and no sellers. This is the thing. Market participants are less, so property value become fair value. When you show fair market value, it will be a little bit lower than the comparing 2015-16 time. So anyway, you take nearest selling, 1 year gap or 2 year gap maximum, 2018 September onwards, or to August September, 1.5 years gap. So you will get many examples from many values from there. Take whatever you see. After all, this is our judgment. You know the value of the price of the land when you see even a broker can say. You need not be a highly qualified valuer. When you go, you use thumb rules, some thumb rules. That is called four-way thumb rules. It is devised by Sri Kanaka Sabhabadi sir. That is first question. With my hard-earned money, my hard-earned money, will I borrow that property with this price, whatever in my mind? If it is no, leave it, reduce. Then what I will do with this property tomorrow? Next question. See these 4 questions. Then what I will achieve if I sell in next few days? if there will be any profit for me. Similarly, you can arrive a rate in market value yourself. Then you make inquiry, and finally, this is kind of reverse calculation, I will say. Very frankly, no faculty will say this. So it's kind of reverse mathematics. You know the value, you arrive it. I hope you got my point. I cannot explicitly say how. Right? So this is the thing. So Javaji is related to
Market value.
Market value. Okay, the next one. Chimanlal. Chimanlal Hargovindas versus the Slav. That is land acquisition. The court cannot take into account
Hello.
the award. Hello, yes.
Good morning.
Good morning. Good morning. Who is this?
Oh, sir.
Hello. Good morning. Who is this? May I know your good name, sir? Okay, fine. You didn't hear me. The court cannot take into account the award passed by the SLAO unless it is produced and proved before the court. The court cannot take into account of the market value is to be determined as on the date of publication of the annexer 12/6 notification. Leave the annexer 12/6. As I told you, the market value is to be determined on date of publication of the notification. Date of, this is very important word, date of publication of the notification, not date of publication or date of notification. This is date of publication of notification. This is 1 mark question. That's why I'm stressing this point. Date of publication of notice under section 4 LA. Plus factors and minus factors are to be, as I told you, plus factors and minus factors are to be considered while determining the market value. Exactly. What is plus factors or minus factors? Civil amenities, width of the road, approach road. If it is bigger road, you will get a higher value. You will fetch higher value. Then shape of the land. Then any stigma is attached to it. Stigma means, you know, some property, some people, I don't know, cemetery is there, cremation center is there. They won't prefer that. So there are stigmas. That is called social stigmas. That will reduce the value. So various social stigmas are there. So that point of view. Then demand supply. It's also like a very important aspect to be considered. Whether it is highly demand area or highly populated area, if people are willing to buy or not, those kind of things. That is plus factors and minus factors are to be considered determining the amount. So I think you can Chimandal can be related to land acquisition, publication of notification part. Publication of notification part. So Chimandal is the man who 1 mark reason for the 1 mark question for date of publication of notification. I hope you got the point. So relate to Chimanlal to our 1 mark date of publication of notification. Okay. I hope you are clear.
Yes, sir.
Okay, fine. But you are not happy, huh? Anyway, okay, let's go. We'll continue. Controller of state duty, estate duty versus Radha Devi. See these three now onwards. These 4 more or less same. Only slight difference is there. These are newly added in the new syllabus, which remove the previous syllabus. It was not there. Instead of that, some other pronouncement of judgment is there. So this is new one. Radha Devi Jalan. So rental property must be valued by rental method. First point. Rental property must be valued by rental method. How do you value rental method? Which approach you use? Tell me. At least you tell me that one. In which approach of
Income.
valuation? Very good. Income approach. Okay, fine. Very good. So rented property must be valued by rental method. In case of building which are in possession of tenant and tenants cannot either be evicted or rent payable by them cannot be enhanced except in accordance with the provisions of the Rent Act. Rent Act means Rent Control Act. The only appropriate method of valuation is to capitalize the annual rent by certain number of years of purchase. So this is related to rent as well as years of purchase. You should know what is years of purchase. Years of purchase you might have learned in at present value given in pound. Okay, a single rate or the present value of 1 rupees receivable at the end of each year after counting for a sinking fund to accumulate at the same rate interest as which acquired on the. You may be knowing this single rate and sinking fund method and all income effect method. It is clearly we learned about it and just revise it. You will find this what is single rate method and years of purchase. So years of purchase is very important. So the second one is method of valuing. The third point, the method of valuing the land and buildings separately and adding up the value would be improper cases because that would ignore the impact of Rent Control Act on the value of land and building. Method of the land building separately, adding up. It is improper in such cases because in bank, okay, because when a bank property we are valuing, if we value for income approach, that is certain kind of commercial activities there. That is why we are doing it as income approach. When it becomes NPA, non-performing asset, the bank has no way to run, no idea, no way to run the show, commercial activity. So what they will do? They will sell it as land and building method. That is why we prefer land and not we. Banks are preferred land and building method because suppose the building is 50 years old, they are running a very good profitable business, or they were running in past. Sudden loss occurred. They cannot put back the money back. So what they will do? It becomes NPA. The bank has to take over, say auction it. So what auction price they will get? They will get only the auction price which is for land and building only. The prospective buyer may not be interested in to do that particular commercial activity again. So in that case, income method is we cannot do for banks, whereas in IBC laws, where liquidation process or whatever process or CLAT cases, we have to do by this method, income approach method. So rent payable them cannot be except in accordance with the method of valuing land and building separately adding up would be improper in such cases because that would ignore the impact of Rent Control Act. This one is not commercial activity. This is rent only. This is connected only with the renter. Radha Devi Jalan case. Rent Control Act. This is also income. Same thing. Commercial activity also you are getting or an industry. You are getting a profit. This is like a profit. When you get your agreement. As per your agreement, you have to do the maintenance. Okay, minus it. If you are liable to pay the tax, then deduct it. These are, that's why I'm telling this is case study question. Case study means your 20 mark question, 16 plus 4 or something like that. So so that will come in under this for this act is you should remember what are the why we are going for rental method, because is the method valuing land and building separately and it is improper in such cases. This is the right method. Not just read it. Okay, fine. Tell me.
What supposedly the building is both owner occupied and rented. How to go about that?
That we are coming in the next case. Okay. Okay. Now years of purchase we have seen. Okay, fine. Now Srimati, Ashima Sinha. So this is the case of Commissioner of Income Tax versus Srimati Ashima Sinha. Again, you see, the court approved of tribunal's decision to allow 10% deduction in value to account for sale of undivided share in the property. So actually, you cannot sell undivided property is not marketable because why? It is a tangible concept to say, correct? You cannot show this is my property, undivided share. This is my share. No, in a flat or apartment, you cannot say. So the court approved tribunal's decision to allow 10% deduction in value to account for sale of undivided share in the property. Now, the second thing, the court has held that in the method adopted by the valuation officer, the value of the land taken twice. Very important point. This you remember. In the method adopted, he has taken the amount included in the yield method again under the revisionary method. This is a novel approach, but in our view, erroneous. That means court view. That is erroneous. Why? See, yield method, you have arrived value for the property. Then you need not add revisionary. Revisionary means giving back the land after the lease period or rent period. You need not go for it because this is already included in yield method. I'll tell you one thing. The engineers know. There is say square meter. We go for square meter. 100 square meter land. What is the coverage? Generally for residential building, 50 or 60%. Am I right? Am I right or not? See, 600 meter, 100 square meter land is there. You want to construct an apartment or whatever. You have to leave some portion of the land, right? You can build only to 60 to 50%. The rest 40 to 50%. Right? It is unoccupied, vacant. It is vacant, no. An ordinary person say it is vacant, but an engineer should know that is mandatory to leave that portion for whatever purpose, rainwater harvesting or kids play area or whatever. That vacant land is not. It is actually a part of that building. So what happens in yield method? It is already taken into account. So again, under revisionary method, that means the land given back after the lease period or rental period is not to be considered. Why add up all those things? You already arrived at a method, value by yield method. Then no need to add the land when it is returned. Am I correct? Right. So it is an error. So it is you connect it with some name. Okay, what is that? Ashima. Okay, Ashima Sinha. Ashima Sinha can be connected to yield method. A revisionary method should not use. You keep in mind. In this method, only yield method, revisionary land value should not be considered again to get the market value. Okay, that is the main point. I put a note on it. The Calcutta High Court has virtually held that there is no such thing as revisionary value. Calcutta High Court has virtually held that there is no such thing as revisionary value, but still, in some cases, lease agreements we are taking it. Anyway, revisionary value and the concept of revisionary value is erroneous. It is wrong. It is well known that courts have to consider only the evidence duly produced and arguments submitted before them in the court. It seems that the advocates submitting arguments on behalf of valuation officer have not properly understood the logical reasoning behind the revisionary value. There should be some reasoning. It is not there, revisionary value. Therefore, failed in producing proper evidence and property presenting the concept of revisionary value before the High Court. The High Court has therefore misled in
delivering such absolutely incorrect and erroneous judgment. It needs to be cautioned at this stage that the judgment of the court should always be read in the context of the evidence, duly proved, and arguments submitted before the court charter should never be followed blindly. This is the thing. So you cannot add revisionary value in this case, whose case? Ashima Sinha case. No revisionary value. So you can say Ashima Sinha case related to no revisionary value, only yield value. Okay. Remember like that. You relate with something, as you like to by heart this. Now comes Anup Kumar Kapoor and others, Commissioner of Income Tax. Anup Kumar Kapoor. What is that? Again, this is more or all the same thing. The valuation officer under the method adopted by him has taken the value of the land twice. Value of the land twice. Once in arriving the figure by yield or rental method. This yield or rental method already land and building is there. You understand? I hope you understand. You will understand definitely, because income fetching method, yield and it is undivided share of land, everything is included in this one. Then again revisionary method is used. See, this is why I'm telling this is case study case. Same thing, it is repeating. As previous two, revisionary method applying the so rental method again applying the revisionary method is wrong. This is our view was wholly wrong. In this case, Calcutta rejected concept of revisionary value of land. The above case was fully tenanted property. Obviously, therefore, land reversion was not possible, and hence it could not be added. This is in the case of fully tenanted, as you asked me. Somebody has asked me now. Introduce yourself, please, when you ask, okay? So that I can clarify it. So this is fully occupied, rented by tenants. Now, the last one. Bhagavan Das Patel, Commissioner of Income Tax versus Bhagavan Das Patel. What he says, the rate of capitalization should not unreal and must have regard to commercial rate of return after taking into consideration of the various constraints and insecurities in the property of the market. So this is Bhagwan Das Patel. It is for commercial rate of return. After second point, after considering payment provision versus 11 bar ULCR Act. What is ULCR? Urban Ceiling Act, Regulation Ceiling. The ULCR Act of 1976. The court opined, in our opinion, the reasonable and appropriate rate of capitalization would be 8 and 1/3. That is 8.33333 times the net average annual income, which would give yield of 12%. 12% per annum on the investment of capital property. See, this is a simple question they are going to ask you. Don't confuse why capitalization is 8.33, how you get 12%. Just 100 divided by 8.33, how much? 12%. This is called yield. So yield is calculated by capitalization method. 100 divided by what is yield? 8.333, 8 and 1/3. So you will get 12%. Clear? In our opinion, reasonable and appropriate rate of capitalization would be 8.33 times. It is return 8 and 1/3. Okay, I will say for if you have a calculator, you can easily find out now. 1000 divided by 100 divided by 8.333, it will come near to 12,000. Near to no, it is 12%. The 12% per annum of investment in capital in the property. So this is the I will give you the ULCR, the Urban Land Ceiling Regulation Act 1976. This is for urban land. See, mostly in cities, metro cities, in places like semi-urban or rural area, it may not be applicable. The stated purpose of the law is bringing about an equitable distribution of land in urban agglomerations to subserve the common good. This is for the well-being of the people. This rule has made Urban Land Sealing and Regulation Act. So I think yes, we have finished 10 judgments. So if you want, we will go again one by one. Learn it today itself, so that you don't have to spend time more time. Okay, this is the one. First one is Rustam C. Cooper, which is tangible and intangible, etc. It comes under it. So 25th Amendment also you can remember, where the fundamental right, property become constitutional right, not fundamental right. Rustam. Okay. Sorab Talati. Court approved investment theory to fix standard rent of rent control premises, return in gilt-edged security. Gilt-edged security. By heart, it gilt-edged security is the basis of determining fair return, landlord investment, etc. That examples are given. A reasonable rate of return. You need not go this one. 1.5 strong now. It is still maybe less. It started by from 5%. Now it is 1.5. I taken from some other books. So you need not worry about this thing. Commonwealth, what is that? Commission of Wealth Tax. Then that is related to PN Sikkim. What is that? PN Sikkim 50% unearned increase. Sikkim means unearned increase to the lessee. Okay. Wagner. Wagner is combination with the owner occupied, sale adapted, DVS not. That's the question you ask. Okay. Whether is owner occupied or sale compares, whatever it may be, it relates to assessment of annual value of self-occupied building, and annual value must be determined on the basis of the standard rent. See, if at all owner occupied, you go for the expected rent, for the particular property. See, this is wealth tax. Excuse me. Okay. So everything should be in one method only. Don't go for this is for wealth tax. See, suppose in your IBB exam, if they ask particular owner occupied, that is different case. And lessee occupied, you have to calculate separately. Whereas this Wagner case comes under wealth tax, DVO, Divisional Valuation Officer. This is applicable in capital gain and other things. See the difference. This is for taxation purpose and other things. Rent control. So this is the difference. Wagner is related to this one. Then Javaji, then is versus revenue. Again, basic value register prepared stamp duty. This is not applicable. I got found that basic valuation registers no evidentiary value, that has no statutory basis. This is the judgment which we apply for valuation for banks and all. So Javanji is related to us. Then comes Chimanlal Hargovindas. What is that? The court cannot take into account what proposed by SLAO unless it is proved before the court. The market value is determined as on public date of publication of notification. That is his role, Chimanlal. Date of publication of notification. Plus or minus factors are to be taken. Then comes Radha Devi. Same thing. Next three, these are all more or less same. These four. Okay. I hope you got my point. Oh my God. I cannot see you when I share the slides. No. Okay. Now, any doubt? Clear, no? So this 10 judgments you can learn today itself. No more learning for you finish it of today itself. No doubt on it, because the question will ask, the word comes, you write the name. The particular word will come in question, unearned increase or market value, stamp duty, whatever comes, relate to that particular judgment and finish it off. And most probably the last four questions they won't ask, I think. I hope so, because minor difference is there. Minor that you can check with that. I will share you that judgment now. Check the what is the minute difference in the judgment. That is all. So actually my class is over now, but I don't want to go now. I have promised, because once I take a class, I want you to be happy. I want to be happy. It's kind of passion for me. So let us go for a case study cases. What do you suggest now? Shall we go for a total FAQ type MCQ question? A typical
MCQ questions.
IBBA.
That will be better, sir.
Yeah. So we will go for a typical IBBA question. I mean MCQs only, not case studies, because case studies takes another half day or full day. So I'm not going through that deep. That we'll see later. Now we'll see some of the FAQs, frequently asked questions, FAQ in MCQ. Okay. So I will share a slide. You can answer is there. You can pick up the answer and we will explain. I put the answer also with the along with it. Okay, can you see this? First question.
It's not readable, sir.
Okay, I will read for you. I will share it to you. Okay.
Okay.
The property value is, I don't know why you are not seeing. Is there something wrong? I'm not an expert in PPT. Okay, anyway, I'll read it for you. The property value is rupees 1 lakh. Expected salvage value is 2000 after 5 years. What is the rate of depreciation? Can you calculate now? Property value is 1 lakh, sorry, 1 lakh. Expected salvage value is only 2000 after 5 years. What is the rate of depreciation?
98,000 divided by 5.
So 19.65. That means you the given options are A 20%, B 19.6, C 30, D 15. In this case, you can use a technique because the others are whole numbers. This is the only decimal place, more accurate maybe. And the lengthier answer question, you can prefer that one if you want. If you want to, you are a risk taker, you can go for that, even if you don't know. See, the others are whole numbers 20, 30, 15. This is the only figure 19.6 because how it got 1000 minus salvage value 2000 divided by number of years. 98 divided by 20,000. This is wrong. 20,000. Okay. This is wrong.
20,000.
Okay, 20,000. Then only you'll get 98. No. No. 1 lakh. Oh, this is
80,000 then.
Am I correct? 20,000? Shall I make 20,000? Okay. Then 98 comes. Whatever. 98 by 5. So 19.6. Now, another question. A mobile phone was purchased for rupees 50,000. Its salvage value is 10,000. Total lifetime use. Mobile time. Mobile is based on hours, mobiles and generators, etc. Total time used is 60,000 hours. Used time is 20,000. What is the depreciation of the cell phone? A, B, C, D. So you will get 50,000 minus 10,000 already used, divided by 6,000, 13.33. So none of the above. D. Answer is D. Clear? Hello? Anybody is having doubt, please ask me. These are general questions, usual questions, similar questions will come. Not exactly the same. A mobile phone was purchased rupees 50,000. Salvage value is 10,000. Total time usage is 60,000 hours. Used time 20,000. What is the depreciation? So how will you calculate? 50,000 is the price minus 10,000 salvage value. So 40,000 multiplied by 20,000 divided by 60,000, because 20,000 is used already, divided by 60. That will give you 13.33. Just check it in your calculator. 40,000 into 20,000 but divided by 60,000. That is 13.33. This is the depreciation of the phone. Generally, we will take all the electronic gadgets nowadays 15%, because it is changing now. Mobile phone, after 2 or 3 years, people are changing, throwing away. So it is use and throw culture now. So so many electronic waste is dumping. It is now it's a global issue how to remove these things. So anyway, that is one of our environmental part. The question is clear now. Answer is clear. Whether it is clear, the depreciation calculation. Is this
Yes,
clear?
Readable,
Okay.
readable.
Okay. Somebody has to say next question, please. Okay. Now, next question. Cost of acquisition 8,000. Salvage value 10,000. Life of the machine is 3 years. For WV, WDV, what is WDV?
Written down value.
Correct. Exactly. Please tell. Okay. Very good. It is written down. What is the depreciation rate? How will you find out the depreciation written down value method? Okay, come on. This is the method. That is 50%. First day 8,000 into 0.5 into 0.5 into 0.5. That is first year 1,000. First year always consider as 1,000. Then comes 25% decrease, 33.75. Next 60. Next 100. So, this is the easiest formula. A is equal to the linear constant method. No, same formula you can use. A is equal to P 1 minus R raised to n. It will go outside. This R raised to n. This outside bracket. Since I cannot do it, okay, go. Okay, this is the formula. A is 8,000. A has to find out. So P, what is that? P 8,000. 1 minus R. R is rate of depreciation. Divided by 100 raised to n. How many? N is years. How many years? This is the formula to find out depreciation for written down value also. In this case, this is 1,000 rupees after 3 years. You apply this formula if you want. Do you have a scientific calculator? You must learn to use in our time, in my time. I will tell you, we don't have this much functions. It should not be programmable calculator. You cannot take a programmable calculator, but you can go with, I think I am using this one, Casio FX991ES. This type
Scientific
of
calculator.
scientific calculator. This type of, you should. Many people are not accustomed with it like me, but I learned from my daughter. She is also doing my job. So she passed in 2018. So she learned me these functions. So how to make raise to n, all those things. This one step it can be done. 8,000. If she's there, I will call her and I see, just put 8,000. Then you have got an option for bracket, option bracket 1 minus 0.5. 0.5. 5% is depreciation. It has already told. So let us take, we know 5 divided by 100 upper, then 0.05. What is that? Depreciation, right? Okay. So you have to find out R. Yeah, 0.5. Depreciation rate 50%. 50%. 8,000 by 0.7 to 0.7 to 0.5 thousand. Oh, yes, okay. So yes, that salvage value is 1,000. So in order to get 1,000 in 3 years, you apply here 8,000. Here you use this value. You have to find out 1,000. You have no. This is 1,000. A is equal to 1,000. P is equal to 800. 1 minus R raised to R by 10 raised to 3 years. N 3 years. Then you have to find R. Here R is the unknown factor. They are asked for R. So when you calculate by this method, mathematical method, that is A is equal to P into 1 minus R by 100 raised to N. So you will get R very easily. This is this method I wrote. This not that good, because this is trial and error method. 50%, 80,000, 8,000 into 0.5 into 0.5 thousand. These are all. If it is 25, you will get 3,375. If it is 66, you will get 314. If it is 100%, you will get 0. So you should get 1,000. So that is the question. No, salvage value is 1,000. So you should after 3 years you are getting 1,000 here. So 3 years. So 800 is equal to 1,000 is equal to 800 into 1 minus R by 100 raised to 3. Then you will find R. 50% you will get. If you want to try now. Any doubt? I think you may have some doubt. Any doubt? Please ask. Is it clear? I hope it is clear. Can I move? Next question. Hello.
Yes, sir.
Yes, sir.
It is clear, no?
Yes, sir.
Any doubt you just please ask. Because this is a good question. That's why. See, I'll explain in 1 second. See, cost of acquisition is 8,000. Salvage value is 1,000. Life of machine is 3 years. So that means after life of the machine, you will get 1,000 rupees if you sell second hand. For return down value, what is the method? What this is an illustration. If it is 50%, how much? 3 years. 8,000 into 0.5 into 0.5 into 0.5, right? That will come 10,000. If it is 25%, 8,000 into 75 into 75 into 75, 3,375. That means 25 minus 75. 25, 100 minus 25, 75. The 100, this is 100 minus 66, 0.34, 0.34, 0.34. Then you will get 314. And if it is 100%, it is 0. So we should get answer 1,000. So 1,000. This is done by trial and error method. All the values you are taken. If it is 50, 50%. If it's 25, 75%. If it is 66, 34%. If it is 100, 0%. So better you use this formula. You have learned this formula in cost approach. A is equal to P into 1 minus R by 100 raised to N. This is cost approach. Forget about those 4 formulas you learned in income approach. Complicated formulas, no. You may be remembering income approach. We have learned for formula: sinking fund method, dual rate method, present value, those things. So forget about all that part. Don't confuse cost approach and income approach. Whenever you use income approach, only you think about income approach formula. Income, I mean, when you go for cost approach, go linear method and straight line method, return down method, whatever method you have learned. So there is a formula for this. So this is the formula for return down value also. Constant linear method also, this formula we are using. Now next question. The net income was reported at 24,000 and the property sold for 3 lakh. What capitalization rate is applied this sale? Very easy. Net income was reported 24,000. So 24,000 divided by 3 lakh into 100. This is the capitalization. Capitalization rate. I hope you got it. Very simple. Then comes the age of the building is 20 years. The life of building is 40 years. Replacement cost in as on 2018 is 5,000. The salvage value is 500. Using straight line method, what is the depreciated rate? What is depreciation rate? Again, the first question, same. 5,000 is the salvage rupees replacement cost, 5,000 minus salvage value divided by 1 into 20 years. Now the age, total age 40 years, 20 by 40, you will get 2,250. That is depreciation rate. This question comes. This is the same question has appeared once. Even when I wrote the exam, the same question was done. Everybody will tick 2255. Where is that? This one. The first one, A, 2250. It is wrong because that is depreciation. Now you have to find depreciated rate. So for depreciated rate, you should minus. It should be minus from the total rate. 5,000 minus 2250. That is 2750. Option C. Option C is 2,750. Very, very careful there. Even though we know it, we will go wrong in this case. Similar case, they are asking depreciation. You see that what is the question? What is depreciated rate? They are not asking depreciation rate. Both are different. Depreciation rate is the whatever the depreciation value. Depreciated rate means market value minus whatever replacement value minus depreciation. That will give you depreciated rate. So take care this wordings, depreciated rate. A person seek similar cases. So let us leave it. Later I will circulate this to among you. These are all similar case. I have got some more. This is all cost. Some. As per SURFACE Act, this property is not considered as a security to the bank. Which property? As per SURFACE Act, tell me. Residential flat, commercial building, residential home. Agricultural land, exactly. So agricultural land never falls under SURFACE Act. which is not considered as a marketable property? Restaurant, hospital, cinema theater, temple.
Temple.
Exactly. While calculating the depreciation of RCC roof bearing, this aspect is not seen. Okay. While calculating the depreciation of a 40 years RCC roof load bearing structure, this aspect is not seen. Which aspect? Replacement cost of construction, age of building, economic life of building, physical life of the building. While calculating depreciation of 40 years. This is as per IT, Income Tax Department Act. The physical life is not considered. Only economic life is considered, age is considered, replacement value is considered. Physical life is need not consider 40 years. Okay, because in I think as per wealth tax, 40% is the maximum depreciation for a building. Remember that for IBB it is different. As per Wealth Tax Act, registered as a 34 AB wealth registered valuer, you may be knowing that for a residential building, 40% is the maximum depreciation. You cannot go beyond that. So physical that thing you remember, then physical life of the building is not considered. Okay. Which of the following is not duty and function of a valuer? It's a simple one. Duty comes under like this: to verify ownership document. Okay, it is our duty. Occupancy on actual site. Okay, our duty. To identify plot number in document as well as on the site. Yes, plot number, everything has to be we check. Then we investigate the property of to be valued. We will investigate with people, but we won't do responsible for correctness of survey findings by his assistant. See, so not some questions will contain definitely not. Which of the following is not a duty of function of the valuer? So here it is survey findings by his assistant. It's very clear. We need not take into account. Such kind of questions don't leave. While valuing asset which is value is not considered on the features. We go for frequently asked. They may ask this one: as an independent valuer, the valuer should not charge dash fee. Fill in the blanks. Professional fee, success fee, mandate fee. Yes. Okay, fine. Success fee. These are all common questions. I will circulate this one. Now comes under section number RARA, common area means open parking space, terrace, and staircase. D. On not they are given separately: open parking, terrace, staircase. All is common under common area. So you write D. Okay. Open parking is a common area. Terrace is a common area. Staircase is a common area. Now, question of honest proof when both parties need evidence will vary. Other see in what is it called Indian contract. When you go through that contract act, you will find it. So I think better to sign off.
Sure.
I will share it. Definitely, I will share it. And it is Sunday. I know you people are all eager to go. You cannot go outside, no. These are some of the questions which I can tell me, sir. Sanjeev, sir.
Sir, kindly share material, maximum material you have with you.
Oh, of
Maximum.
course, sure, definitely. I'll share it within 1 or 2 days. Everything will be shared, and keep in touch with me and with each other, all of you. And best, method is combined study. Combined study is the most effective method for IBBA. So whenever you have a chance with the study with others, you can have the Zoom meeting yourself, 1 or 3 people together, or 4, or all of you, and make a combined study. Prepare within 1 month. You can pass this exam, no doubt about it. 1 month given. You are all familiar with most of the classes, no? So whenever you have a doubt, you can call me. In my telephone number is given. You can write it down, 9495636151, or you can mail me. Better mail me, manon63@gmail.com.
9495.
9495. Better, can you write down in mail, because sometimes my phone will be out of range. It's rainy season, no? It is flooding here nearby. I can
No
see.
problem,
So better to write in my mail ID is easy. Manon63 MENON 63. That is my date of birth. 63 Manon63 @gmail.com. No space, no gaps, nothing. Manon63 @gmail.com. You can write any question you have doubt. I'll talk to my, if I don't know, I'll talk to my other faculty members. I'll come back to you with answer. Okay. This is a way we have to interact, and you can, being AI or VF members, you can have a combined study. It is better always. I advise you to have a combined study. In our time, there is no such online meetings. It's not possible. Now it is COVID. This is a blessing in disguise for those who are appearing for IBBA, because my mandatory classes were in Trichy, far away from my place, not in my state itself, Tamil Nadu. Then I stayed there 10 days to study this with all the faculty members. So that was different experience, of course. So online study is more easy. You can sit in your classroom comfortably, and whenever you get time, you adjust your timing and make a comment study. Whenever you need me, call me. I will also join if you want, without any remuneration or anything. I'm expecting just to have a word with you and all. Thank you very much, and thank you for participating. And I especially thank Kumar Gupta ji for arranging this session. Wonderful participant. So thank you very much. And
Thank you, sir.
I hand over my.
Thank you, sir.
Thank you very much.
Yes, sir. Thank you.
So I'm leaving. You can discuss in between you. I am leaving the class. Thank you very much.
Thank you.
Thank you, sir.